Lordship, it's a transfer application, Lordship, a CRR.
Next circuit, next circuit.
Right.
Huh? Next circuit. Huh? Next circuit, next circuit.
Your
Next.
Lordship,
Item number 1.
I am
Correction.
going for extension of claim order.
Next circuit.
Your Lordship, they will permit to mention one matter correction.
Correction queue.
Lordship, in this case,
Item number 1.
Lordship, I am for the insurance company. In para 12, appellant, Lordship.
Para 12.
Here it will be appellant. It will be wrongly related claimant. Para 12,
The insurance company has deposited the statutory amount.
and the claimant will withdraw. Now, it is appellant. Insurance company is statutory.
The claimant has the insurance company has deposited statutory amount of 20 claimant is acha. But what about the amount? That amount
I will give it in the trial.
in paragraph. The matrix this has to be mentioned for correction in the order dated 13th May 2025. Counsel for the appellant insurance company submit that in paragraph 12. It is recorded that the claimants have the liberty to withdraw the amount, but it should be a appellants have liberty to withdraw the amount. In view of the above, in paragraph 12, line number 2, in place of claimants, it should be read as appellants. Appellants.
All the claim.
Yes,
And the third line also, the claimant requested to the
which?
line number 3.
Line number 3.
2, 3.
And, paragraph 12, line number 3, 2 and 3, the word claimant shall be replaced as appellants.
Item number 2.
My lord, I am for the petition item number 2.
Yes.
My lord, in the earlier question, your lordship asked for the injury report, my lord.
Yes.
Your lordship asked for the injury report too.
Huh?
It is injury report, my lord. You are asked for the injury report.
What is the section?
My lord, the section is under 329 clause 4, 115 clause 2, 117 clause 2, 118 clause 2, 109, 74, 303 clause 2, and 3 and 5 of VNS, my lord. My lord, as per the allegation is concerned, this present petitioner went to the de facto complainant's sister house and using some filthy languages and assaulted the de facto complainant's sister and her son, my lord. And also took some amount of money along with some ornaments. My lord, the actual fact is that prior to this complaint, my lord, another complaint has been lodged by the petitioner number 1 and 2, mother, my lord. Kindly see the complaint, my lord, annexure P2, my lord, page number 11, my lord. At that complaint, my lord, the de facto complainant husband and along with all the family members assaulted this present petitioner along with the petitioner mother, my lord. And I also annexed the treatment sheet, my lord, in page number 13 and 14, my lord. It is an absolutely false and fabricated complaint, my lord, which arose due to the land dispute, my lord, between the family members.
Then what will happen? So between family member, you will assault.
My lord, prior to this complaint, they have assaulted me, and I have also lodged this complaint prior to their complaint, my lord. Page number, my lord, kindly see 11, my lord.
Abatement of suicide.
No, my lord, no abatement of suicide, my lord.
109. Attempt to murder.
Murder.
109.
Yes.
What is the injury?
Holding the CD, madam.
No, not really.
Can the back is possible, madam?
Good.
Item number 3.
Item number 3, Your Lordship, I beg to appeal for the de facto complainant. I beg to appeal to also petition. Your Lordship,
Yes.
in the matter, we have only served with a notice that the matter will be listed today, but no application has been served to us. If an
Lordship,
application,
I have given a
application to the state authority, because last time direction was given to the state to deliver the copy.
Yes,
The last occasion.
Only a application can be served upon us because we only received this notice yesterday, Your Lordship.
Shaidul.
item number 3, you are appealing.
Yes, sir.
CD is there.
No, CD is not there. Just pass over. All the CDs are there on the way, madam.
Pass over.
Your Lordship, in between, a copy of the application may be served upon us. My colleague is there, Your Lordship.
Yes.
Shohidul Khandakar. Oh, this is Shohidul Ali.
Shohidul Ali.
Oh, this is Shohidul Khandakar. Shohidul Ali, madam. This is the CD. Because item number 4, that is also Shohidul.
Yes.
And this is the injury report, madam. Last page. Last page of the CD is there.
Who is the victim? What is the name of the victim?
Lord.
Who is the complainant?
Complainant is the my lord, the cousin, my lord.
What is the name?
Name is my lord, Momir Hussain.
And who is the victim? To whom he assaulted?
Victim is the
What is the
brother,
name?
brother, my lord.
What is the name?
The sister name is Urfa Khatun, my lord, and the son is Shohidul Sheikh, my lord.
In this case, my lord, in the other counter case, which was filed, my lord, in that case, these accused were behind the bar for 14 days. After 14 days, they were released. And it's a family, though it's a
Family dispute, my lord. It's
But
a
even
completely
then, my
family
lord,
dispute, my lord.
They were custody for 14 days, my lord.
My lord, they are completely innocent, my lord.
Who?
This present petitioner, my lord.
Ah. How he
Due to
said
the
that
land
they are
dispute, my lord,
innocent?
this quarrel took place and
Who is the
this-
victim?
victim is the my lord, the complainant
What is the
sister.
name?
Name is the Urfa Khatun and my lord Shahidul Sheikh, my lord. The
So you are obtained on how many victims are there?
Kojun injured. One injured.
What is the name? Arfa Khatun.
Arfa.
What is the stage of the investigation?
Charge sheet has not been filed. This is a case of 10th of March 2026. One of the last occasion we collected the injury.
Nothing.
My lord, I have cooperated with the investigation officer.
Have you seen the injury?
Yes, sir.
Cut injury
My lord.
on the right eyebrow, swelling abrasion in the both hand. That's all.
But only I'm concerned because in the counter case, my lord, though I don't know what was that case. In that case, they were arrested or they surrendered, whatever it is, my lord, they were behind the bar in 14 days.
14
My
days.
lord, in that case also they have assaulted mercilessly also with the dire consequences, my
How
lord.
many petitions are here?
3 petitioners, my lord.
Who are they?
My lord, Shahidul Ali, Raidul Hussain, Rahul Hussain.
All three went to the house of the
Well,
complainant.
this is the allegation, my lord.
Yes.
Nothing was, as per their version, this is a completely concocted story, my
We
lord.
have 2 cases. The injury which was they have suffered means custody, my lord. That injury was in the head.
Yes, my lord. Kindly see the page number 13, my lord.
In custody 14 days. Here the injury is on hand.
The petitioner has filed the present application for grant of anticipatory bail in connection with Pundibari Police Station case number 178 of 2026 dated 10th of March 2026 under section 329 within bracket 4 slash 115 within bracket 2 slash 117 within bracket 2 slash 118 within bracket 2 slash 109 slash 74 slash 303 within bracket 2 slash 3 within bracket 5 of the PNS 2023 pending for the Learned Chief Judicial Magistrate at Bhuj, Bihar. Counsel for the petition submitted the de facto complainant has made a false complaint, and on the basis of the same, the accused persons have been on the basis of the same false on the basis of the police has registered the above case. He submitted the petitioners had been to the house of the sister of the complainant, and the complainant has made a false report to the police that the accused person, the petitioners, have assaulted with the weapon. He further submitted the accused persons are permanent resident. Where they are residing?
But they should be out of the that area. They should be for the next one or
They
few months.
are the permanent
Till
resident
the
of the
submission of the charge sheet. my lord.
Pundibari police station, and they will not, and they will appear before the police station on each and every date of, they will appear before the investigating officer and cooperate with the investigating officer. Full stop. As per the order passed by this court, the PP in charge along with the IO is present. Produce the CD. This court find that the allegation against the petitioners are that the petitioners had been to the house of the sister of the complainant, and the petitioners have initially abused the complainant and thereafter have assaulted the complainant, due to which the assaulted the victim, due to which the victim has sustained injury. Produce the injury report wherein it is found that a cut injury on examination, it was found that the victim has sustained cut injury over the right eyebrow and swelling abrasion on the both hands. Consider the injury report. This could find that the injury alleged and sustained by the complainant is simple in nature. Simple in nature. Full stop. This could further find that there is no necessity of the custodial interrogation of the petitioners of the instant case. In view of the above, in the event of arrest, in view of the above, the anticipatory bail application is allowed. In the event of arrest, the petitioners shall be released on bail on furnishing bond of rupees 2,000 with one surety each of the like amount, 2,000 of each of like amount. Full stop. The petitioners shall, lady or both? The petitioners shall appear before the investigating officer once in a week, and shall not, but where they are residing?
No, the area, they should not enter the area. Except for the Harira. Some stringent conditions.
The petitioners shall not entered into the jurisdiction of PS Pundibari till the filing of the report in final form by the police before the learned court. Full stop. Except to meeting with the IO once in a week. Except for meeting the IO once in a week. Till the full stop. meeting that the petitioner shall meet BIA once in a week till the final report is filed.
Grateful.
CRM services will disposed of CD will return.
Item number 4. Oh. Item number 3.
Yes.
The allegations are under section 124. 329 172 previous act, 74 outrage of modesty, 78 of stalking, mischief, and mischief. There is no allegation of falsehood against this particular petitioners. The FIR is at page 10.
Your Lordship,
Paragraph.
Your Lordship, I am for the de facto
Yes.
I am for the de facto complaint. Your Lordship, I have received only a paper of notice stating that a matter will be listed today. No application has been served upon me, Your Lordship. I'm only praying for a copy of the application, Your Lordship. I may come back within an hour, Your Lordship.
Within an hour.
At 12, Your Lordship can take up the matter. I'll come back, Your Lordship. A copy may be served upon us, Your Lordship. My colleague is there, Mr. Nigam Mittal. He'll collect
You're not
the
served.
Yes, sir, the
Served? Who is here? Who is your colleague here?
Mr. Nigam Mittal, Your Lordship, he is there in the premises.
He's not, no.
Your Lordship,
They cannot
10 to-
search of your colleague in the premises.
Lordship,
Where you?
he's not-
Nobody's here.
Your Lordship, he'll collect, Your Lordship. I'll apologize, Your Lordship.
Okay.
He'll be there.
Excuse me, Meghna Joshi, can you please text me in the WhatsApp?
Yes, Your Lordship. I'll
Give
do
me a
that.
copy, send to me. I'll serve.
I have already delivered the copy to your office.
No,
Next,
not mine.
Item number 4.
I'm grateful, Your Lordship.
Lordship, I am for the petitioner.
What is this, CD?
My lord. My lord, the de facto complainant is
CD is there?
on her way, my lord.
Huh?
CD is
De
there.
facto complainant is on her way, my lord.
Huh?
My lord, it is, her presence is required, my lord.
Why?
My lord, some instructions are required, my lord. Kindly, my lord,
Why you are always delay?
kindly make it possible.
Yesterday you were delay, not today your client is in delay.
My lord, kindly. my lord.
Yesterday you are making submission, you could not reach because of the
No,
traffic.
no, no.
Today your client is not reaching the
My
court.
lord, short possible.
Pass on.
Item number 5.
For the petitioner. My lord, in this case, my lord, the petition number 5 has already been arrested.
Petition number 5.
5 has already been arrested.
Good. Then.
My lord, so far the rest petitioners are concerned,
Hmm.
1 to 4.
Hmm.
If your lordship kindly take the page number 9, that is the entire allegation leveled against the accused number 1 and 8.
Hmm.
May I permit to read out, my lord?
Hmm.
আমি বাধ্য হয়ে পাশের জমিতে কাজ করছিলাম, আমার জ্যাঠাদাদা সুশান্ত মাঝি চিৎকার করে ডাকি, ঘটনাটি জানাই। তিনি প্রতিবাদ করলে অভিযুক্ত 1 নম্বর ও 8 নম্বর, দ্যাট ইজ নারায়ণ পাল and রাজু ব্যাপারী, who are not the petitioner here,
Hmm.
লোহার রড দিয়ে অত্যন্ত নৃশংসভাবে সুশান্ত মাঝির উপর আক্রমণ চালায়, তার শরীর ও মাথা বিভিন্ন আঘাত করতে থাকে। এবং সাবসিকুয়েন্টলি উই হ্যাভ বিন ইমপ্লিকেটেড। এই সময় 2 থেকে 7 নম্বর অভিযুক্তরা এসে ঘটনাস্থলে সংঘবদ্ধভাবে আক্রমণ চালায়।
Hmm.
The allegation against the 2 to 7, that is, my lord, petition number 1 to 4 are omnibus in nature. They are the family members of the.
I'm not holding the CD, my lord. 95.
Why?
Malwala.
Can we pass over with this take some time?
Password.
Password.
Item number 6.
I am appealing for the petitioner.
Yes.
Lordship, the allegation is under section 9, 10 and 11 of
Notice
the.
served.
Yes, Lordship.
Notice upon the victim.
Yes, Lordship. Victim is appearing.
You are appearing.
Victim's mother,
Huh?
victim's mother is present, my lord.
Allegation is under section 9, 10 and 11 of the Child Marriage Act, read with section 6 of the POCSO Act, but against the petitioner, section 6 does not apply. They are the father.
Lordship, service to the victim is not
Huh?
affected. Service of the victim is not affected, Lordship.
Not affected.
No, Lordship.
When the matter was filed?
Lordship, the matter was filed on, so the, because of insufficient address, Lordship, the person has
to?
been returned.
To whom?
From victim, Lordship.
To the
person-
victim.
Yes, Lordship.
Insufficient address.
Yes, Lordship.
Why?
Lordship, because the address which is given in the Lordship document are not proper. That the,
So serve
if the
to
state
the-
is convicted,
so-
Lordship,
serve to the
this was the-
officer in charge.
which is returned.
Which address you sent?
Lordship, the address of the de facto complaint, Lordship, which is given in the FIR.
Huh?
The address which is given in the FIR, Lordship.
To the public.
Near
prosecutor.
Ganesh Mandir,
Where is the notice to the victim?
Lordship. In the affidavit, Lordship.
প্রধান নম্বর 132
It is only to APP. Where is the notice to the victim?
Lordship, in that later pages, Lordship, there is a postal.
Where is the letter? Where is the communication letter? Where is the communication letter, forwarding letter?
Lordship, I have posted that, Lordship.
See, the letter addressed to the APP. Where is the letter to the victim?
এই 3 নম্বরটা কি হলো
Darjeeling. Yes, which police station? Which police station?
This is a প্রধান নম্বর case.
Pradhan Nagar.
Police have served again. Notice has to be served, then we'll serve the notice.
That's why. The land counsel for the petitioner has filed
Give us a
affidavit of
copy.
service. But the notice could not be served upon the victim. Accordingly, petitioner is directed to serve the notice to the victim through the officer in charge of Pradhan Nagar Police Station. The petition is directed to immediately serve the copy to the London APP in charge. Copy of the application along with the document to the London APP in charge to cause service upon the victim. Release the matter before the next circuit bench. Eight. Yes. What, POXO?
ভালোবাসেন না আপনারা holding the CD হলো
What is the stage of the investigation? When the FIR was March.
April laws in the month of 27th of March.
What is the stage of the investigation?
Stage of investigation. This is proceeding is going on, madam. But the victim is still traumatized.
What is the age?
Traumatized, madam, after the incident.
What is the age?
Age of the victim is.
Where's the injury report? Medical report is there?
Yes, ma'am. Not yet served.
Let me see whether victim is required to be heard or not. Why the victim is to be unnecessary brought before this court if there is an. That's why, let me see the, let me see this.
Report is there, madam.
That is, where is the injury report? Medical report?
Medical report, sir. She was admitted and discharged.
Refused.
Is the married lady. The married lady.
The married lady? There will be no case. There is a case.
The case is that I am a regular customer of his grocery shop.
Correct.
Subsequently, on the date of incident, taking advantage of no one in the home, I tried to break her, not my lord base. As per FIR, if your lordship kindly see, FIR, last 5 lines.
Hmm.
Of the last 5 lines, আমাকে প্রশ্ন করে
চেষ্টা করি।
Allegation of
Then
the case of my lord molestation, not molest. Attempt. Attempt to that there is an objection.
yes,
Who is there? Medical is in. My lord, the case
Michael
is that
denied.
local people.
What the 164, same FIR.
Our case is that local people came to the spot upon hearing his view and fact and kindly see any independent witnesses who corroborate the version of the victim.
376 independent witnesses required.
My lord, case of.
Yes,
If it is so, they have to be arrested. Independent witnesses in front of them, rape is committed on. If they don't protest.
give the name who is an eyewitness, I will record it.
But madam, she in her FIR stated that local people came to the spot upon hearing his view and fact. That is why I am saying, madam, kindly see whether any witness who corroborate the incident of the victim. That is making lazy.
The petitioner has filed the present application praying for grant of anticipatory bail in connection with Malbazar Police Station case number 115 of 2026 dated 27th of March 2026 under section 329 within bracket 4/351 within bracket 3/62/64 of the BNS 2023. Counsel for the petition submitted the victim has falsely implicated the petitioners in the present case. He further submit that from the FIR itself, it reveals that only the allegation that the petitioner tried to commit rape, but there is no allegation of rape. He further submit that as per the allegation, when the victim, it is allegation that the petitioner has threatened the victim not to say anything to any other person. Counsel for the petition, he submitted if the anticipatory bail is granted, the petition will appear before the investigating officer and cooperate with the investigation. Learned counsel for the learned APP in charge along with the investigating officer is present, produce the case diary. This could find that as per the complaint, produce the case diary, this could find that it is the complaint that the petitioner tried to sexually assault the victim. And subsequently, the victim has made a written complaint to the police officer, the police has initiated the case. From the case diary, it found that the victim refused to medically examine, and as such, medically examined, and the report is filed wherein it is categorically mentioned that refused to medical examination. Consider the submission made by the counsel for the respective parties for the case diary. This court find that it is the only case of the petition, only case of the prosecution that the victim had tried to sexually assault the victim. But when the case has been registered and the victim was taken to the hospital for medical examination, she refused to medically examine. Considering above, this court find that the custodial interrogation is not required. Custodial interrogation is not required. Accordingly, in the event of arrest, the petitioner shall be released on furnishing bond of rupees 20,000 with two surety. One must be local. The petitioner shall appear before the investigating officer on each and once in a week till the report in final form is filed and submitted. The petitioner shall not hamper or tamper with the evidence and shall appear before the trial court on each and every date of the day. CD be returned. Next.
9.
The allegations are under section 128, 117, 118, 109 of the of the case is that there was an hot altercation taking place in between both the parties, and both the parties have received several minor scratches. As per the instruction I have received, there is no such previous injury caused to the victim.
How many accused persons?
Actually, here is one.
How many persons are involved in the FIR, in the case?
Only one.
Only one. 109.
Yes.
What injury the victim?
Neck injury, serious in nature. We have the photographs and at least 32 is the injury.
Chapdichi.
The instruction will see both the parties.
Maybe, but injury is very dangerous, madam.
Serious. The fifth case, it's
What is the weapon you seized? What is the weapon? Weapon used? Weapon not seized.
This custodial interrogation is different. It's a sharp weapon, my lord. Injury we can easily, my lord, can. Sharp and dangerous.
You not obtain the report from the doctor.
Injury report is there.
Injury report with regard to the opinion.
Oh.
What is the ingredients of the 109? You are not obtaining report from the the doctor whether the injury is sufficient to cause death.
Measurement has to be there, brother.
There is a specific. It has to be taken. The investigating agency has to take a report from the doctor whether the injury cause is sufficient to cause death if the proper treatment is not given immediate.
That we can actually, had it been so, then simple injury would have come, brother.
That's why.
the neck and the
No,
injury-
that's correct. Neck, I
They have
find the
stated
injury
it's a
is
serious injury. Serious injury means it can occur in that case, my lord. Very good of
Huh?
Details of admission are also required for that.
No, not. That chapter over 20 days. Even without the assault, intention is enough to convict this person under 307. Correct? If intention proved. Sorry. The petitioner has filed the present application for grant of anticipatory bail in connection with Bhakti Nagar Police Station case number 44 of 2026 dated 16 January 2026 under section 128 within bracket 2/117 within bracket 2/118 within bracket 2/109/351 within bracket 2/3 within bracket 5 of the BNS 2023. Counsel for the petition submitted, there is a dispute between two families and the petitioner has been falsely implicated in the present case. See, further submitted, the victim is alleged to have been sustained a severe injury and he was not admitted in the hospital for 20 days and 20 days. See, further submitted, the petitioner is a permanent resident of within the jurisdiction of Bhakti Nagar Police Station. If the anticipatory bail is granted, some other petitioner will appear before the investigating officer and will cooperate with the investigation. And an APP in charge is present along with the investigating officer and CD is produced. This police stop. This court find that the victim has sustained the injury over the neck and is serious in nature, full stop. Due to the absconding of the petitioner, the investigating agency could not seize the the weapon used for the alleged offense. According this, in view of the above, this court find that the custodial interrogation of the petition is required. In view of the above, the CRM number census is dismissed.
10,
Yes. Yes. What is the section? 109. All 109. Why so much case of the 109 here? Injury report is there. What is the injury? Sole accused. You are the principal accused. What about the other accused person? They are arrested? No.
Okay.
Injury is grievous. The
Though the attack was done with a bow, but the injury seems to be simple.
but face and all these things. Side to face injury, nose, skin, scalp. Simple is, but where they have attacked the total face. The petitioner has filed the present application for grant of anticipatory bail in connection with Mathabanga PS case number 212 of 2026 dated 1st of April 2026 under section 126 within bracket 2/117 within bracket 2/118 within bracket 2/109/351/3/5 of the Bharatiya Nyaya Sanhita 2023. Counsel for the petition submit that the petition has been falsely implicated in the present case and the petition is no way connected in the present case. Full stop. Immediately when the petitioner came to know about the initiation of the instant case, the petitioner has filed the present application for grant of anticipatory bail. Planner PP in charge is present along with the IO, produce the case diary. Produce the injury report, though the injury is simple in nature, but the victim has sustained the injury on the face, right side of the face, nose, skin, scalp, and scalp. Full stop. This could find that the investigation is going on and to ascertain with regard to the use of weapon by the petitioner, the custodial interrogation is required. Accordingly, this court is not inclined to grant anticipatory bail. CRM census dismissed. Next.
11,
Yes.
Petitioner purchased a car.
Huh?
Petitioner purchased a car.
Two insurance policies.
Petitioner approached the opposite party number 2 and was provided with a counterfeit insurance. Later on, met with an accident. The Tata showroom provided another different insurance policy to your petitioner and stated that the earlier insurance policy was fake at counter. Thereafter, the petitioner's vehicle met with an accident. Petitioner had to spend ₹5 lakhs from his own pocket to get his vehicle repaired. Thereafter,
Yes, where is the report?
moreover, the petitioner's vehicle was lying
Yes.
in the showroom for more than. But we have already said that the report has not been received.
Then I will call because the order was passed on 24th of March.
But then just pass over, I'll come back at 12 minutes. Just pass over.
Come. Pass over. I will take the matter now.
12,
Item number 12, I issue on behalf of the petitioner matter, the direction for service matter. Service is not common. Honestly, by mistake.
Not completed. Counsel for the petitioner submitted the notice could not be served upon the opposite parties and he pays for time. In view of the above, let the matter appear before the next available circuit bench. The petition is directed to file the affidavit service on the next date. Next.
13,
13, your lordship. 13, your lordship, I am appealing for the petitioner. Your lordship, kindly recollect, my lord, the false case of kidnapping, my lord, the pro forma opposite party 2 and the petitioner number 1. They have already got married and they are residing peacefully. Lordship, I am filing the supplementary affidavit, my lord, annexing the marriage certificate. And as per your lordship's direction, my lord, the husband and wife is there, my lord.
They are present, my lord. Husband and wife.
What is the age?
Thank you for this.
Huh?
My lord, both are major.
Where is the birth certificate?
Birth certificate.
Birth certificate is with my junior friend, lordship, she will hand over.
ছেলেটা অফিসে গেছে কেন পাঠিয়েছিল অফিসে পানিটা
Birth certificate and school certificate.
তেরোটা লিখে দাও
They are now residing, staying as husband and wife, my lord.
What is the case? How many accused persons?
My lord, the petitioner number 1 is the principal accused is the husband, and 2 to 8 are their the in-laws, lordship, the relatives of the petitioner number 1.
The de facto complainant is the mother of the wife.
So,
So, my lord, they have already got married. This is a false case of kidnapping. My lord, they are major. I have annexed the marriage certificate in the supplementary affidavit, lordship. Lord, besides that, my lord, there are a number of complaints from the side of the pro forma opposite party number 2. I have annexed in my petition saying that her parents are not, my lord, are disturbing their peaceful married life. To the IC, to the superintendent of police, to the SDPO, everyone, lordship.
This is a case, my lord, where the girl's parents are not approving her choice. Basically, that is the case, my lord. But they are happily with each other. I've also had a discussion with them. So they are happy with each other.
yes, who is for the state?
for the statement. The last occasion also same thing, I mean, they were supposed to file the certificate.
Yes, supplementary affidavit is there.
The petitioners have filed the present application being CRR 164 of 2026 under section 442 read with section 528 of the Bharatiya Nagrik Suraksha Sanhita 2023 corresponding to section 482 of the Code of Criminal Procedure 1973 praying for quashing of the criminal proceedings being here case number 533 of 2026 arising out of Mata Manga Police Station case number 247 of 2026 dated 15th April 2026 under section 137 within bracket 2/140 within bracket 3/126 within bracket 2/115 within bracket 2/117 within bracket 2/303 within bracket 2/351 within bracket 2 and 3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023 pending before the learned additional chief judicial magistrate at Mathabanga, Kuch Bihar. Here.
Just
Counsel
that.
for the petition submit that the victim was major and for her own consent went with the petitioner number one, but only on the basis of the false complaint of the mother of the victim, the police has registered the above case. Counsel for the petitioner submit that the victim and the petitioner number one has already married, full stop, and already married, full stop. The petitioner has filed the supplementary affidavit disclosing the certificate 30th March 2026, the marriage between the petitioner, 30th March
2026.
Yeah,
Yes,
the
Your
marriage
Lordship.
between the petitioner and victim was solemnized in presence of the witnesses. Full stop. The victim and the petitioner is present in person before this court. The victim has produced the original birth certificate wherein it reveals that the date of birth of the victim is 10/12/2026, wherein which reveals that the victim
2006, my lord.
2006, which reveals that the victim is major. Considering the above, full stop. This court has also inquired from the victim and the victim in person, and victim submitted that she herself went with the petitioner number one, and they have married in accordance with they have married with each other, and the petitioner has not committed any offense against the victim. Consider the above, this court find that the victim is a major girl. She had a love affair with the petitioner number one. And with the love, she left the house of the complainant, and subsequently they have married and started residing separately with the petitioner, and they are residing. The victim and the petitioner number one is residing together. Considering the above facts, this court find that no purpose should be. This court find that as the victim and the petitioner number one have married with each other and residing together, and thus no purpose should be served for for sending this matter for trial. In view of the above, the case initiated by the Mathabanga Police Station, being case number 247 of 2026, dated 15th of April 2026, under section 7, which is pending before the Learned Court of Additional Chief Magistrate at Mathabanga, Kujbihar, being CR case number 533 of 2026, set aside and passed. CR number so disposed of.
Grateful.
The original birth certificate and the school certificate is returned to the victim.
Grateful, Your Lordship.
Next.
14 to 18.
Yes.
The CD was called for. Don't know whether the CD has been summoned. Pradhannagar. Siliguri Omen and Pradhannagar.
No.
But can it be fixed tomorrow?
What is last day?
Because we have already intimated, my lord. Thing is that yesterday there was some VIP movements. That's why it's a problem. But tomorrow we can bring in the tomorrow to
Why 498 4 cases?
But thing is that, my lord, previously, because
That's
if there was
correct,
a
okay.
case pending previously, the Anas, they didn't take the FIR. Now the thing is that there is an instruction from the superior officer, whatever the complaint is filed, go for a preliminary inquiry and register a case if you find anything.
Correct. You registered the case, but there is a provision. Once you find that the investigation already the case, and either it has to the supplementary charge sheet is filed in the original case.
My lord.
That's all. with the leave of the court, you can file a
That
supplementary
is the problem we are,
affidavit.
nowadays,
So
my
how
lord,
the,
we have seen that.
see, how you tried these 4 cases?
But the cause of actions are separate.
I,
It's not a same cause of
no,
action.
that's why I've gone through. I was the same opinion.
But
When I, then
until
when I was signing the order, then I find, no, it is something else.
yes. The thing is that, my lord, until and unless we are divorced, my lord, still the relation is a husband and wife. So automatically, if a mental
How
or
the-
physical torture from
see,
the end of
one-
the husband,
The first complaint which she has lodged, she is stating that already been ousted.
mine,
Correct.
I will not
And
speak,
498 and all the things has been incorporated.
my lord.
Once they are not residing from the date of the FIR first, subsequently the FIR,
So
how,
the facts are different.
how the 498, okay, theft, okay, you can ascertain, assault, okay, you can ascertain, yes, he went and assaulted, on he have game,
But the status is of wife, my lord.
but 498.
If it is of status of wife, because the
How the-
definition of
Sir,
498,
498 ingredients, how much time you will convict the person for 498?
that's true, my lord. A multiplicity of-
How you convict the person for
The
498?
section says that if the husband or his family members, that is the reason why the, my lord, the investigating officer, they are putting this section. my lord. Until and unless, if it has been a divorce case, my lord, already divorced, then that's a separate thing. Thing is a separate cause of action, sir.
Notice was issued.
Yes,
It is
sir.
directed to inform the defective company.
Yes, sir, notice was.
So notice served? No.
Notice,
Notice,
I
sir.
am appearing for the.
You are appearing. So how?
The cause of action difference, no, and below.
How 4 times of 498? Tell me. Leave aside other sections. You tell me how the 498 in 4
If
dates.
the husband assaulted, if the husband assaulted the wife.
498.
No, that is good.
Read, give the IPC. 498. Read. 498 ingredients.
And below cause of.
Read the 498 ingredients. Assaulted, if the assault is the only the assault is the 498 ingredient.
But husband or relative of husband of a woman subjected to her cruelty.
Cruelty. Assault is cruelty.
Cruelty, assault and without
Then read.
whoever being a husband or relative of a husband of a woman subject such woman to cruelty shall be punished with imprisonment for a time which may extend to 3 years or shall also be
So,
liable to.
Every assault, every cruelty.
And also, they
Mutual divorce filed in the year 2019.
mutual divorce
After expiry of 4 months,
he
4 years.
he forced me to
Okay,
sign
I will hear hearing now. Come to the first case.
the-
Come to the first case. Where is the first case? Now I will hear the matter. Very interesting. CR 110. Yeah, first case 110.
Yes.
CRR. Now I am telling the complainant. Let the complainant satisfy, then I will hear the you.
So prior to reading out the complaint, the backdrop of the entire case, I am just.
Let me first, I don't want the rest to come to the 110. This is the first FIR.
Yes, first affair is at page number 31. Finish.
Got it? You
Yes.
got that?
Yes.
No, I am telling the defective complainant. I want to hear the defective complainant.
I take the phone.
What is the complaint?
বেঙ্গলি মেয়াজি আমি শ্রীমতী গীতা শর্মা স্বর্গীয়
Now, kindly get charge sheet. Page 37.
Mr. Siri.
Got it? Charge sheet? Now, brief fact of the case. Read.
that on 7/10/2021,
Please mind the date.
7/10/2021.
Yes.
15:30 hours, received a written complaint of Srimati Gita Sharma, daughter of such and such Milot, Race apartment, flat number such and such.
She is the complainant?
Complainant.
Then
Yes.
read.
To the effect that the husband, namely Anirban Chakraborty, son of place such and such, ward number such and such, Milot, tortured physically, mentally upon the complainant since long. And as a result, she started living separately, but on 2/10/2021 at around 16 hours, alleged person along with one unknown entered into her house and assaulted her and threatened her. Based on the stated above,
So-
the case.
So you were started residing separately from 2nd of October 2021. 7th of October 2021, the incident was occurred. Correct?
Second.
2nd October, you started residing. And 7th of October, you have made a complaint. The FIR is chalked out. Right? What is the offense? What is the section?
498.
498, 323. No problem. There's a first offense. Okay, we'll go to that. Now second FIR. 111. Now kindly come to the page 34. I don't know the certified copy. Charge sheet. Kindly come to the charge sheet. Clause 16, brief fact of the case.
34.
Got it? Read the brief fact of the case.
That on 27/7/2021,
Ah.
written complaint was lodged by Srimati Gita Sharma, such and such, Anirban Chakraborty, husband, Jhana Chakraborty, mother-in-law, and Rupali Karani, and Deepa Chakraborty, sister-in-law, to the effect that complaint was married in Anirban Chakraborty on 6/5/16 at Sevo Kalibari, such and such. As per Hindu rights and custom, and again he got married on 8 May 2017 in presence of her husband, family member, Sri Kalibari, Hindu estate, such and such. Hindu rights and custom. And soon after the marriage, she was
Read
tortured.
this paragraph. Read. Soon after the marriage, she was
Subjected to torture by her mother-in-law with the instigator of the above noted sister-in-law and forcefully ousted her from the matrimonial house, and she was shifted in a flat of Tagapur, which belongs to her husband. And complained and her husband stated to live there. After the birth of the girl child on 1st February 2018, under the influence of her above noted in-laws, the husband also started to abuse her and torture her mentally and physically, and also driven out from the said flat.
That's
Finding
not
no
it.
other alternative, she stated.
So these are 2018.
Yes.
This is incident 2018.
Incident, my lord.
Child on Ethan,
No.
there are influence of liquor, so and so. Then on 18/4/2020, her mother-in-law and husband forcibly entered into the
2018.
complainant house.
2000.
So now this FIR, read with the first FIR. What is the soon after? What is the allegation made in the second FIR that is not in the first FIR?
He has not indicated the first.
Then,
He has not.
so how you can sustain this allegation in the second FIR? How you can improve your case? In the first FIR, that allegation is not here, 2018. Then can you come to the third FIR?
Incident is before 2018.
No.
18.
She has made the first complaint on
2018.
7th October 2021. That was the first complaint. That complaint, the simple allegation that they have tortured and started living separately from 2nd of October 2020. That's why 498 and 323. And second FIR is dated 27/7/2021.
No.
Which FIR is first one?
The first one, my lord, this is the first one.
This is the first one.
This is the first.
Okay. So this is
This is
first
the
one.
first one. Thereafter, my lord,
This is
FIR of which date?
so okay. If it is the second one, 111 is the second FIR, first FIR.
Yes.
So where is the allegation with regard to the first FIR in the 7th of October 2021?
Yes, Lord.
Have you mentioned that earlier also he has committed an offense, he made a complaint and FIR is chalked out? Where is that?
Second FIR.
Second FIR not mentioned about the first FIR?
That we are living separately and.
No, I already made a complaint. FIR is chalked out, but in spite of that, he has come in
Then, my
and
lord, the police would have tagged it with that. one.
that's what I'm telling. That's what I'm telling.
So there is
correct.
a separation.
Correct. Now this separation, now come to the third. Because what you are understanding, I was on impression of the same.
Yes, my lord.
When I have gone through the record, then I find no, there is something else. Where is the charge sheet here? Mr. Shah,
Charge sheet and
Justice, Lord.
this is
There
also
are two
the-
options, my lord. Why that?
This is also same.
Why
This is
that-
also the 111 FIR. Where, what is the FIR number here?
FIR number 99, Siliguri PS.
99, that 99. The
99,
same is the
21.
111.
No.
These are the similar.
CRR 260.
These are similar with
Similar.
regard to 111.
Yes,
Correct.
yes.
So there are two. You file now the fourth one.
Fourth one, CRR 492 of 2024.
529 FIR for
Yes, 529.
Where is the charge sheet?
Justice, Lord.
You have not disclosed the charge sheet here.
Sorry, charge sheet was not, when it was filed, that at that point of time, charge sheet was not filed. So since I was facing that earlier two proceeding, that's why the repeat version, that's why I filed the quasi application. Meanwhile, whether I don't know whether the charge sheet has been submitted or not.
Now kindly come to the fourth case. Fourth case FIR.
Fourth
Page
case, FIR,
13.
last page. Last page.
Okay. Where is the allegation?
Wait. May I read out? Ashif?
Yes. Show the FIR for the third FIR. Got it? Yes.
বাড়ি ফিরে এসেছিল হ্যাঁ ম্যাট্রিমোনিয়াল হোম এসেছিল
Yes, my lord. Second, I got married on my lord.
Leave aside the second also. Leave aside third also. Now fourth also. Now fifth.
Also,
Before the date of marriage of the so and so,
Yes, five.
I had known him for 5 years and could not judge his behavior and ill intention, and thus since the day of my marriage, my husband and his family members started torturing me and harassing me both physically and mentally. Along with my husband, following persons under the name equally responsible for harassing me and plotting against me
There is no
for
date.
trying to kill me.
There is no date.
So there is no occurrence.
There is
Sorry.
no date of paragraph 5. Now come to the come to the paragraph 6. My husband following persons are under the name equally responsible for harassing me and pointing me. When already you have made a complaint. Paragraph 6.
no, there is no date.
Then paragraph 7, 8. Now kindly come to the paragraph 13.
Only 13.
No, come. That is pen added. That is pen added.
Yes.
Because the police want, there is no case. Now you added with the pen on 14th 8. Around 8:30 again, he attacked me, hit me with the car and stone.
my lord, the
Correct.
Correct.
it has to be a distinct and fresh cause of distinct and also fresh cause of action.
I appreciate. Okay, you assaulted with the car or pelting stone, whether 498.
My lord.
498. Then I can kindly come to the last one.
It's the difference between same cause of action and fresh cause of
I will
action,
send
my
you to
lord.
the Guinness Book of World Records, sir. Now, what is the number of the fifth one? FIR number?
764.
FIR number?
764 of 2024.
Where is that?
Page
764.
78. 78 page.
Yes. Now, again you read. My husband and his men
I
and agents were
petitioned
directed
that
to
on-
stay
on,
away from my
26/11/2024 at around 12 p.m. My mother-in-law, namely Shimla Jhana Chakraborty, wife of Sacha, came to flat and with 2 men and 2 women and without any notice and illegally broken
Then?
and lock and key. Milord, kindly see, there is a Milord dispute, there is a torture, there is a assault. Milord, kindly see some, Milord, he forcefully entered my flat and broken the flat and also assaulted. Milord, kindly see the injury to that. Kindly see this day. Milord, kindly
This
see for a
is
movement.
not-
Milord, for a movement. Only one thing.
See, here is the, I am not on the point
kindly-
of,
kindly-
I am only on the point of
Milord,
law.
Milord,
I am
police
only,
did not.
give the answer to the point of law. Give the answer to the point of law. Without
Maybe, Milord,
mentioning in every complaint with regard to the initial FIR, it is not
Because,
suppression
Milord,
of fact.
Because Milord, such several days.
That's why,
several days-
I asked for these two, but the other two charge sheet is there. The other two charge sheet is not there. What the police has done in these two matters.
Produce the minor CV.
Then
But
tomorrow
can
he
these
will, he will
cases-
absent.
The can,
Yes,
if the, if
tomorrow.
my
Tomorrow
lord,
he will absent his
my lord,
valid.
if my lord
First-
finds,
first day I am.
my lord, if my lord finds that these cases are of same cause of
Milord,
action,
may I say
then
one
my
thing?
lord can merge the cases.
No.
If it is a
can't-
different, it's a fresh cause of actions are there, my lord.
Yes.
If it is same,
No, my only question with regard to, see, 498A. How much time you take the 498A? That is the only question. Man, the witness may say they came and assaulted, they pelted the stone, they've taken my, whatever it is. But the 498 cannot be, it might be 323, it might be the 379.
my lord, thing is that, my lord, maybe there must be some confusion on the part of the. Thing is that, my lord, can these all cases be merged and a time limit may be given?
How you
my lord?
can, how you can proceed? How you can proceed if it is merged? Automatically there will be a contradiction of the victim. The complainant is only one.
Complaint is one.
Then how you can proceed? And if all witnesses have been taken into consideration, it will be taken 100 witness.
What I can find, my lord, these are not the first FIR, second FIR is not the carbon copy of the first FIR. It's not
Not.
like that, my lord. There are certain things, there are certain new facts are there and the old facts have not been, they have been
Only
suppressed.
facts what? He came with the car. What is that? He came to my house. Nothing else.
Daily bickering between the
Milord,
spouse cannot be a
There, Milord, there is a, yes, it is true, Milord. The husband is the advocate.
My lord,
And
it is
this is the Siliguri
CD of item number 16.
Item number?
16 today. 260 here.
260.
This is a different FIR. Siliguri woman police station case number 99. It covers both. Triple
Item
one
number
and 260.
15 and 16, CD is one. Same
Yes.
CD.
Yes.
Yes.
প্রধান নাম কত?
Again 498, 406. How the where is the extradition has been taken? After third FIR on the 406, 498.
Recovery nil charge sheet in the charge sheet.
Yes.
দুজনে কি লয়ার নাকি?
Huh?
Husband only lawyer.
Husband is?
Lawyer.
Then?
And the wife knows better than the laws. No?
Kindly for a moment, kindly see the Milord. Only.
This is not the part of the charge sheet.
Milord, police did not seize Milord. Please.
You didn't.
Where is your application?
Exactly.
Police did not seize.
Where is your
Police
application?
did not properly investigate. Police did not.
In which case you wanted to produce that?
Milord, in this case, Milord.
In which case? And what is the date of that occurrence?
Milord,
That photograph?
photograph, Milord, differential.
Eh?
Milord, kindly for a moment. Wow.
Yes, tell me. So go give them law point.
Milord, this
Are
photograph
you
is- Milord,
you
they
you
forcefully
satisfied
enter
this
and
court? I
broken
am
the
giving.
door. Milord, kindly see broken the
Give.
door. Then Milord, I took instruction in which date he is.
Yes. So what has happened?
This is the some injury is there, Milord.
Hmm. Can you say this is the fresh injury? Can you say this is a fresh injury? And this is the injury by any weapon? Yes.
Okay, one thing,
Ah.
only this is the 5 matter. Kindly direct the planet board below. Same code, this is pending. Only five matters pending in the same code. Analogous matter.
No, I was that, but how you can prove?
Exactly. No tribal case is made out.
The court has to
If the-
see
if
in the for the 482 whether you can prove. How you can prove 498? How much time? That is the only here. If it is a different section, the court could have been dismissed, but 498 in 5 times. Tell me. What about the other charge sheet, 2 charge sheet?
Well, another Pradhan Nagar PS case number 764, my lord. That CD I'm not holding. I have one CD.
That is the problem.
এটা আনা যাবে দেখো না একবার আসছে কি But can it be fixed at 2, my lord? Then we'll try once.
Come at 2 with the charge
Because
sheet.
my lord has already parted the matter, so at 2 we will come back.
Only I want to see the charge sheet.
My lord, দেখো তো দেখো তাড়াতাড়ি একটা পাঠাতে বলো সার্টিফিকেট করে তোমাকে এটা পাঠাতে
You also come ready at 2.
এটা তো আছেই
Next.
I don't know, 19.
So I am for the petitioner. So in this matter, Lordship was pleased to direct the learned prosecutor to bring the charge, the CD.
CD is
So
there.
kindly see the Lordship can recollect the this matter from the order sheet 12th of May 2023.
Yes.
12th of May 2023. Order.
12th May.
12th May 2023. Yes.
Yes, ask for them. What is the matter?
Matter is that an allegation and the FIR was registered under section 365 and 511 against 3 accused persons where the petitioner was not named. During the course of with the allegation, gist of the allegation is that there was a pre-existing commercial dispute by and between the de facto and accused person, where the de facto complainant was liable to pay some amount is due to be paid to the accused person, which was refused, and then and over that incident, this case was registered. Now that during the course of investigation, the notice under section 160 was served upon the petitioner. Along with it, immediately thereafter on the same day, and another notice under section 91 of the Code of Criminal Procedure was simultaneously issued to the petitioner. Now challenging the entire propriety of the legality of simultaneous issuance of 2 different notices, I have come before your Lordship. Now the then Lordship, according the gist of the matter and formulating the issue, has interfered with and granted liberty to the investigating officer to take a particular stand how to deal with the entire situation, provided he should not be treated coarsely. This was the interim protection was given. Subsequently, the next coordinate bench has also had an occurrence, had an opportunity to deal with the issue. And the earlier order, that first order, the investigating officer was directed to cooperate to interrogate the petitioner, while the petitioner was not called on or not interrogated. And the next coordinate bench, by passing on 3rd of May order, the date is 3rd of October 2023, has also given the same direction to the investigating officer to proceed with the investigation, and if required his interrogation, then he can go ahead with it. Despite the same, the petitioner was not called upon, nothing that sort of. Now, meanwhile, the accused person who are 2 accused person has been granted anticipatory bail. 1 accused person was arrested. He has been released on bail by the learned court below. 161 statement, 164 statement was recorded. I got from the order sheet that the dispute was regarding commercial in nature. That's why the bail was granted. However, but I don't know whether charge sheet has been submitted or not. But the expiry of with the passage of 3 years to till date,
What is the section three
the
sixty-five?
petitioner was not never called upon.
The section is 365.
365, 511 attempt.
Correct. So who are you?
I don't know whether I'm an accused or witness. I don't know. I was served with the two.
Filed.
Yes, I don't
It
know.
is filed.
I don't know. He has to.
Yes, report is there.
Yes, my lord.
What is the allegation against the petitioner? What are the incremental material you are?
Charge sheet has not been filed. The next date is fixed on 4th of July for filing of the charge sheet.
Now, what is the incremental material received by you? During investigation 365 Abid 11, whether he was the person accompanied the victim. Or
He
he
is
has-
Ajoy Rai, my lord. As per the thing is that this is an incident of 7th of May 2023
Correct.
at night at about 20 to 30 hours, that is 10:30.
Ah.
He along with one Noor Islam, the complaint was standing with one Noor Islam in front of TVS showroom at Kujbir. On that time, one color Scorpio registration, another vehicle, registration of 2 vehicles came there. And some persons came out from the said vehicle and forcefully tried to kidnap him and Noor Alam, both of them. On shouting, local public rushed to the spot. It is also noted that at that time, 2 uninformed CISF personnel also inside the Scorpio car with firearms. These are the allegations, madam. And during investigation,
How his name? Because kindly come to the how the 160 there will be a CD. What is the date of the 161? 160 notice.
164, I don't know. I got from the
What
order.
is the date of the 161 notice?
Notice date is Lordship.
Where is the notice?
Notice date is 10th of May 2023.
Kindly come to the CD dated 10th May. Kindly come to the CD dated 10th May.
Hey, Radha.
CD dated 10th May.
Seventh May,
10th May CD.
9th May. 10th May, madam.
Yes. What is written?
This is the returning of the PC accused.
Huh?
PC accused returning.
No, 160 notice. Is there any mentioning about the issue of 160 notice? In the CD?
Notice under section 91 and 160 CRPC is there.
To whom?
That's how I sent notice to see Ajoy Rai.
So what? Why? For as a witness or accused?
3 persons were taken into remand, police remand, and after PC, my lord, this Moinak Sarkar,
Is it Bangla
Kuldeep
language?
Jahangir,
CD is in Bangla language?
no English. Also, 164 is also there, page number 36, 37 of the victim Rahul Sen and victim Noor Islam. my lord.
Correct.
And the notice was received by Bithika Roy, the wife of this petitioner. And
Yes,
there
he's
is-
not denying that he is not, he has received the notice.
My lord,
Notice
and
I
under
replied
section
and the
160.
CDR
Also replied. Written reply I made.
and the CDR was collected of Rishabh Sarkar, who is absconding, who called this Ajoy Rai.
What was the premise to issue the notice?
They have, well, they have also given a reply to the notice, page 61.
Yes. No, that's why the 160 notice?
They have given reply that they denied to comply the notice. my lord. They denied because the grounds was, my lord, that there was an interim order of the High Court. From the Honorable High Court, there was an interim order.
no, court
That is
is-
page number 71, 73.
I believe court is on the issue that why the notice was issued. What is the premise?
And page 50, my lord, later on adding sections were there, section 367, 120B. That was on 10th of May.
This time send notice to Ajaras and so which we are under section 90. It is not a 91 notice, it is a 160 notice. 91 CRPC and 160 CRPC, one Scorpio vehicle bearing registration number. All the documents of the vehicle bearing registration mentioned FIR through PS transcript. So, but if see this 10th May 2025, 2023 CD, get them? Correct. And see the notice 160. 91 and 160. 91 is because they wanted with regard to the document of that vehicle, I think it's Scorpio.
Yes,
Correct.
that was complied with.
Just
Sorry.
the vehicle. So whether you have to supply the document
Yes.
by which?
At the CRAN 1, page 21. CRAN 1, page 17 onward.
160 notice can be issued at the initial stage of investigation. It's not that he may be accused, he may be a suspect. To anyone it can be issued,
No,
or a
that's-
witness also.
That's true. So why, what is, you must be in CD. CD requires the production of the
Ah, it's
document.
written, the time returning, my lord, after the 3 accused persons, they were interrogated at the
Ah.
time of police remand. And
Nothing.
then this time, after that, my lord, the prayer, my lord, their statements are there, my lord.
So what you want?
I want that since I have complied with,
Ah.
I enjoyed an interim order.
Ah.
Now, what is the latest status of the investigation? They according to my prosecutor, he has not submitted charge sheet.
What is the necessity of this petitioner?
Grateful.
Where is the
But,
IO?
my lord, the statement of the accused persons are there, the 3 statements.
Hmm.
That is of Manik Sarkar. These are after the time of police, they were in police custody. Kuldeep Janjer and one Bapan
Yes, 3
Sarkar.
persons.
3 persons have stated her name, my lord.
So,
So there is
Even after passage of
so that's why 160 notice was served to him.
what, that's a 160 notice. 160 notice to whom?
To Ajay Rai, this petitioner.
To witness or to accused?
No, that, my lord, at the
So,
initial stage of
You
investigation.
cannot, that's why,
Whether
that
we-
is the challenge
Grateful,
here.
grateful.
160 notice, you cannot take both the laddu in both the hand. 160 notice either to the witness only, can you come to the 160? Attendance of witness.
Only witness, my lord.
Correct, kindly see 160.
any police officer making an investigation under this chapter may by an order in writing require the
Where is the
attendance.
notice, where is the provision for notice to the accused on only 41A?
My lord. Ah, but even if, I'll just,
You can say the 160 is for
my
the
lord,
accused.
anybody who is acquainted with the facts and circumstances.
That's what I'm
my lord.
telling.
41A.
That's what I'm telling. That's why this court wanted to explain whether 160 is for the accused or for wow, because can't you see the the contents of the 160 notice?
Page 15. in exercise of power conferred under section
My lord,
160.
160 CRPC says,
Hmm.
police officer power to require attendance of witnesses.
Ah,
Even my lord, criminal cases,
ah.
the court has the power, a witness can be converted into an accused.
That is subsequent. You cannot play with the witness.
No, at this initial
If
stage
you
of,
produce, that's why I'm telling the where is the IO? IO has to give the justification. This is for either for the witness or the accused. If it is accused, then you have to explain. Why, if it is a non-bailable section, why 160?
that's true.
You can, because if you can summon to any person, produce, subsequently you find that, yes, the document which is produced subsequent to investigation, he can be taken as an accused. It is not, there is no bar, but he is challenging with regard to, kindly see the 160 notice,
Hmm.
page 17. Have you complied with?
Yes.
Have you appeared?
Yes, no, he had not subsequent post passing of the order, they have not called for anymore. Even after passage of 3 years, till date.
What?
Till date, he has, the investigating officer has not called upon me or interrogated, nothing, that sort of. Mechanically kept.
So what you have prayed for under the CRR?
Only-
What you have prayed? What is your prayer in the CRR?
I prayed that,
But though it is a summon to the witness.
setting aside and
But my lord,
revocation of the notice.
Uh,
Revocation or setting
Under the
aside of the
CRR?
notice. Yes,
Under the revision.
yes.
Which provision? Show me.
CRR, in
Yeah, show me which provision.
any legal property can be challenged under section 401,
Hmm.
482
Hmm.
and 397.
So, show me.
but thing is that, my lord, the
Show
settled
me.
principle of law is that
Show me.
160 is actually the notice to be served on the.
Notice of the police officer can be challenged under the revision.
401. 401.
Hmm.
In case of any proceeding, proceeding, the record of which has
Yes.
been called by itself, of which otherwise comes to its knowledge, High Court may, in its discretion, exercise of the power conferred on a court of appeal of section 386, 389, 390, 391, or on the court of the session by section 307, and when the judges comprising the court of revision are equally divided in opinion, the case shall be disposed of in the manner provided under section 392. No order under this section shall be made to the prejudice of the accused or other person unless he has been an opportunity of being heard either personally or by pleader on his defense. Nothing in this section shall be deemed to authorize a High Court to convert a findings of acquittal into one of the conviction, where under the code and appeal lies, no appeal is brought, no proceeding by way of its division shall be entertained at the instance of the party who could have appealed. Where under this code an appeal lies, but an application for revision has been made to the High Court by the person. High Court is satisfied that such person was made under the erroneous belief that no appeal lies thereto, and it is necessary in the interest of justice to so to do. The High Court may treat the application for revision as a petition of appeal and deal with the same accordingly. Kindly see C97. 397.
Call for report.
The call for report. Now, the High Court or Sessions Court may call for and examine the record of any proceeding before any inferior court, criminal court situated within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness and legality and propriety of any findings, sentence, order recorded or passed, or as to the regularity of the proceeding of the inferior court, and may, and upon and when calling for such record, direct that the execution of any sentence order be suspended, and if the accused is in confinement, he be released on bail for his own bond pending examination of the record. Explanation: the magistrate all magistrate whether executive or judicial, or whether or where exercising original or appellate jurisdiction shall be deemed to be inferior to the sessions judge and purpose of the section and section 398. The power of revision conferred under section 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceeding. If an application under this section has been made by any person, either to the High Court or court or session judge, no further application by the same person shall be entertained by them. So the legality and propriety can be challenged in the revisional jurisdiction.
Okay.
This is an admitted position. I have challenged this particular action.
Why? What is the ground for challenging that?
Challenging because that the person who don't know whether he is facing a hyphenated identity, with particularly whether he don't know whether he is an accused or witness, is served with a notice under section 160 simultaneously under section 91 on the same day. So I was
Two notice has been served.
That's it.
Two notice has been
Two
served.
notices have been served.
Yes.
So particularly this particular impropriety of this conduct of the police, I came before your lordship. Lordship was this initially intervened with the matter and directed the investigating officer to take a particular stand to deal with the petitioner.
Okay.
They had enjoyed as many as 3 years till date. I had complied with by supplying the necessary documents sought for to the investigating officer regarding the vehicle and vehicle documents and everything.
Correct.
Till date they are silent. According to my learned prosecutor,
As per the CD, this vehicle was involved in the case.
Yes, my lord.
The vehicle number B60.
Both the vehicles, both this car.
Which
That's
vehicle?
anything further?
One of the vehicles were that it was Butler.
Anything further?
no, so can you
There
see
were
the,
two
I don't
vehicles.
know. No, sir, I don't know whether which vehicle is my learned
Anything is required further?
So,
Argument.
my humble submission
Yes,
is
I
that,
have taken note of it.
that
Yes, anything
since
further?
3 years has already passed,
Okay.
investigating officer did not call me or interrogated me, nothing that sort of. Even from the ongoing investigating findings of the investigation, the public prosecutor could not establish what is my role, whether I would be helpful to the prosecution as a witness or I should be prosecuted as a accused person. Let me clearly, Lordship, let this thing be clear first.
Okay. Record.
My lord,
The petitioner has filed.
My lord, one thing is that regarding section 160, though the head note, it is written summoned to a witness by a police officer. But if my lord goes to the next paragraph, the above what it is written there, it is written any person. So regarding this, there is a discussion. It is reported in 1978 volume 2 Supreme Court cases, page 424, where this, my lord, because there was a confusion in all courts that whether the police officer inspired, there is a 41.
Okay, I will explain. The petitioner has filed the present
So may I say?
revisional application.
So may I say one? I am not disputing that police don't have any power. I'm admitting that.
Present revisional application challenging the impugned notices dated. Impugned notices, what is the date? 10th May 2025.
2023.
Issued by S.I. Sugata Das under section 160 of the CRPC and section 91 of the CRPC to the petitioner in connection with the investigation of FIR number 458 of 2023 dated 7th of May 2023 under section 365/511 of the IPC, registered at the police station Kotwali, Kuch Bihar. Learned counsel for the petitioner has filed, petitioner submit that though the investigating agency has issued the notice under section 160 of CRPC as well as 191 of the CRPC. Though the investigating issued the notice under section 160 of the CRPC, but in the said notice, it is not mentioned whether it is a notice to the witness or as an accused. He further submitted that as per section as per the notice under section 91 of the CRPC, comma, the petitioner has complied with the said notice by supplying the document to the police authority. In support of his submission, comma, the petitioner has filed the CRAN 1 of 2023 disclosing that the petitioner has submitted the documents in connection with the Scorpio vehicle bearing registration number WB64 capital case /8220 and all other documents in connection with this said vehicle. The main contention raised by the petitioner in the present revisional application, that section 160 of the CRPC applies only to the cases of the persons who appears to acquainted with the circumstances of the case. He further submit that investigating officer can issue notice only under section 41A of the Code of Criminal Procedure to the accused. But in the present case, the police authority, the investigating agency has not issued any notice under section 41 capital A of the CRPC. He further submit that by issuing the notice under section 160 of the CRPC, comma, the investigating officer has converted the same as section 41 of the CRPC. He further submit that unless until the police authority will not explain whether the 160 notice under section 160 of the CRPC is issued to the petitioner as an witness or as an accused, comma, the notice is bad in. And as such, the petitioner has invoked the provisions of section 397/401 read with section 482 of the CRPC and filed the present revisional applications. This is the submission.
The judgment relied upon.
What is the judgment? Why you persons are not giving all the thing at a time? The petitioner has relied upon the judgment. Petitioner in support of his submission has relied upon the judgment in the case unreported judgment passed in the case of Anubrata Mandal versus Union of India, passed in WPA number 1839 of 2022, dated 3rd of February 2022, wherein the coordinate bench of this court, which court? Coordinate bench of this court.
Yes, this court.
Wherein the coordinate bench of this court, what is the dealt with?
The identical situation that
Wherein the coordinate bench of this court in the identical situation held that there's nothing. What has been given in this? This is an interim order. Which paragraph you are relying upon?
So I'm sorry. I'm relying upon this paragraph.
This one. This
There are
order.
20. There are 20. No.
This
This is
order.
the new one. There are 26.
Get it. Has relied upon the judgment in the case of unreported judgment in the case of Directorate of Enforcement and others versus State of West Bengal. In WP within bracket criminal 1768 of 2021 and criminal MA 14550 of 2021 dated 7th of December 2021, passed by the Delhi High Court, and submits that the Delhi High Court, which paragraph?
There are 27.
Delhi High Court held that
Para 27, last paragraph, kindly see. Last portion, the highlighted portion.
That someone issued to the petition under section 160 of the CRPC in Delhi, which is not adjoining police station of Rewari, is without jurisdiction and the notice is therefore passed. He further submitted that in the present case also the police has authority have issued, the investigating officer has issued the notice under 160 of the
Jurisdictional
CRPC,
incompetence.
which is who is incompetent to issue the said notice unless such the notice is required to be passed. Police.
Para 27,
Police. Yes.
sorry, para 27 deals with the jurisdictional
The-
issue that
the-
absolutely
the
same issue was
Learned
involved
APP
in my
in
case.
charge, learned APP in charge submits that, learned APP in charge produce the CD and submit that during the investigation and interrogation of the 3 arrested accused persons, comma, the number of the vehicle bearing registration, the vehicle involved during the investigation and during investigation of the 3 accused persons, comma, investigating agency came to know about the vehicle number WB 64 capital K 8220 and found that the petitioner is the registered owner of the said vehicle and the said vehicle alleged to have been used in the said offences. Thus, the investigating officer during the investigation has issued the notices under section 160 of the CRPC by directing the petitioner to appear before the investigating agency and as well as directed to produce the documents in respect of the said vehicle. Learned Counsel appearing for the estate submit that issuing the notice under section 160 of the CRPC and section 91 of the CRPC is in accordance with law, which provides the investigating agency, which give the powers to the investigating agency for proper investigation. The notice can be issued to the person either under section 160 as well as 191 of the CRPC. Learned Police. At the Learned Counsel for the respective parties produce the materials on record. This court find that the police has registered the case. Police of PS Kotwali registered the case registered the case number 458 of 2023 dated 7th of May 2023 under section 365 of the 511 of the IPC. After the registration of the said case, 3 accused persons were arrested.
My lord, 3 arrested.
One arrested, two executable.
No, 3 were arrested in this case. No.
Give the CD.
Yes, Manik Sarkar.
Two has been released and executable.
CD.
Check it.
One. Give the CD.
I'm forwarding them.
Amit Das and Rishabh Das and executable dated 19th of June 2023.
No, 3 was
And-
arrested from the spot.
Hindu Dawn.
One of the Scorpio, they fled away in one Scorpio, one Scorpio was.
Hindu Dawn was arrested. Only one
Anticipatory
person.
bail. And during the investigation, the investigating agency came to know about the involvement of the vehicle bearing registration number WB 64K 8220. The investigating officer has issued the notice under section 160 of the CRPC to the petitioner on 10th of May 2023, which reads as page 70. Page 70. During the investigation, 2 of the 3 accused persons were arrested. Later put करते हैं. This section 91 of the notice issued under section 91 of the CRPC reads as follows. In answer,
ঋষভ সরকার সাইন করেছে তখন বর্মন মনে আছে তখন বর্মন মনে আছে বলছেন
section 160 of the CRPC. Section 160 of the CRPC provides that any police officer making an investigation under this chapter, or any police officer not below the rank as the state government may, by general or special order, prescribe his behalf, acting on requisition of such officer, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. Such persons bound to answer truly all questions relating to such case put to him by such officer, other than the question, the answer to which would have a tendency to expose him to a criminal charge or to a penalty of or forfeiture. The police officer may reduce into writing any statement made to him in the course of an examination under this section, and if he does so, he shall make the separate and true record of the statement of each such person whose statement he records. Okay. It is not denied that the notice issued under section 160 of the CRPC is the investigating officer. The notice shows that the notice is issued to the petitioner directing to appear before the court as and when required or directed, or join the investigation of the case, or disclose all the facts truly without concealing any part of the relevant purpose of investigation, to reach the right conclusion of the case, and produce all relevant materials required for the purpose of investigation, to render all cooperation of the assistance in apprehension of apprehension of accomplice, and will not allow in any manner destruction of evidence relevant to the purpose of investigation of the crime. The notice, after perusing the notice, this court does not find any adversary against the petition. The notice only reveals that the investigating officer has given some direction to the petitioner with regard to the investigation of the particular case. This court failed to appreciate under why the petitioner is apprehending and challenge the notice under section 160 of the CRPC.
My lord.
It is the duty of all the citizens of this country that if an investigation has been started and the investigating agency is required any assistance for the purpose of fair and free investigation, the person has to support the investigation, and if any materials is available with the person, has to supply to the investigation so that the investigation can be completed by the investigating agency. This court did not find any full stop. Considering the above, this court did not find any illegality for issuance of the said notice to the petitioner. This could also find that the investigating officer has issued the notice under section 191 of the CRPC. Section 91 of the CRPC provides for production of documents. Admittedly, the petitioner is the owner of the vehicle bearing registration number WB64K8220. The petitioner has full stop. The investigating agency came to know about the involvement of the said vehicle during the investigation. Thus, the investigating agency has the right to ascertain with regard to the said vehicle. And when the agency came to know that the petitioner is the registered owner of the vehicle, the investigating agency has issued the notice under section 91 of the CRPC. The petitioner has complied with the said notice by submitting the document. But the petitioner has not complied with section 160 of the CRPC. Now the petitioner has taken the plea that the notice has been issued in the year 2023. Now in 2023, within the 3 years, the investigating officer has not asked for any information from the petitioner. This court failed to accept the submission made by the petitioner. The petitioner, at the time of filing, when the application was moved by the petitioner, this court, on the prayer of the petitioner, has directed the investigating agency not to take any coercive action against the petitioner. And as said, the investigating officers have not issued any further notice to the petitioner. The petitioner has filed its application under 397/401/482 of the CRPC. The notice is issued by the investigating agency for the proper investigation. The notice is not with regard to the notice is not issued by passing any order by any competent authority by the court. This is neither the interlocutory order nor the final order. The issuance of the 160 notice is not a proceeding. This is only with regard to the proper investigation. And as such, this court find that neither the application under 397/401 or 482 is maintainable. In view of the above, the CRR number is dismissed.
So one thing maybe.
CRR number is dismissed. The petitioner is directed to comply with the notice issued by the
Also, one thing may I
investigating
point out?
agency within fortnight from date.
So one thing may I point out?
Yes.
So with the order, the coordinate bench order itself, it has been expressly made clear that I made it clear that this
CD
order will not
is
prevent the petitioner
It is
otherwise.
written to the investigating officer, to the CP judge. Next.
Also, may I point out one thing?
Next.
20. Summoning order is challenged also with the divisional jurisdiction. So summoning order is.
Yes, pay
20.
item number.
20.
Item number 20, I'm praying for.
Yes,
Item number 20, I'm praying for next.
what is the matter? You are enjoying the interim order?
No, Lordship.
There is also last objection 9 for the opposite party also. There was a direction, one of the party was died. Production of the case certificate. I also told my client, seeking time.
Divisional application filed by precaution of the initiated NGPR 2020 where the executive magistrate Jalpaiguri drew the proceeding of 107 of the CRPC. You all persons of 107 of CRPC whether the CRR 482 will be maintainable. Why the 397 is there in the CRPC?
Actually, I don't have.
I am dismissing it.
Lordship, kindly make it not.
Sorry.
Lordship, on yesterday it was called for CD. Lordship, my senior is not here. He is in court number 7 on his legs, Lordship.
107, 160, all the things are writ petition. Revisional application. The court has no other work. Where is the proceeding? What is the wrong? If the police has submitted the report against you, what is the duty of the sub-divisional officer, sub-divisional magistrate? He has to pass an order for keeping the person bound to keep in peace by executing a bond, nothing else, and this will continue for the 6 months. You have not been hanged by the executive magistrate.
Lordship, I-
Can you know how much, what is the period of the 107? The executive magistrate can carry out?
6 months.
Then, and 2023? Why out the 107 on all these things you are filing the CRR? Why you are not going to the success court? If there is any illegality.
Actually, my lord, so far the section of 482 is concerned, the sessions court has no power to quash the proceeding.
So, if an executive magistrate has initiated a false case, the session judge is no power, 397.
So, my lord, so far my little understanding is concerned, if there is a legal infirmity, session judge can
Then,
invoke power.
that's why you could have been, you are challenging this order.
I have challenging the proceeding, my lord.
You are challenging this order.
This order.
Correct. If the session judges find that this order is not in accordance with law, what will remains?
My lord, so far the order is concerned, that is an interlocutory order. 397 is not applicable here.
Okay, I am directing to go to the sessions court.
As your lordship give me liberty, I can approach.
You all persons, what the High Court is, what you telling
No,
me?
my
The
lord,
High Court is,
actually, we have challenged the proceeding, not particular order.
where is the proceeding?
My lord, the 107, the proceedings, that is NGR case number.
Where is that? That's what yesterday also, where is the NGR case?
NGR
You have not obtained the all orders and you filed the CRR.
My lord, NGR case number 1586.
Where is that?
That is mentioned in the.
Where is that? Unless
My lord, last occasion, the lordship was pleased to ask the state.
I asked the state, but I am asking you, you are the petitioner.
My lord,
You have to prove this is the NGR case.
My
No
lord,
case is made out under the NGR case. What is
my-
the
my-
Sir, just a minute. What is the NGR case? If complaint has, the police came to know there is
sufficient materials.
not sufficient material.
They have said.
Yes, the police came to know there is a chance of violence, correct, between two parties. If the parties were not bound by a bond by the magistrate,
There
Then-
there may be under situation.
correct,
My lord.
then they used to send the report to the executive magistrate.
My lord.
The executive magistrate, taking into consideration of that complaint,
My lord.
issuing the notice and keeping you in bond.
Bond.
So that's why, so you are telling that you have proceedings. The proceeding has been initiated as per the NJPR case number 2595.
My lord,
Kotwali
1586.
PR number.
PN.
PR number. Where is the PR number? There will be a complaint of this one.
That was not supplied to me.
Where is the averment? Where is the averment you applied and not supplied?
No, that is not
So
my.
you,
part of
once
my
you
order.
receive the notice, you have to apply for the certified copy before the executive magistrate. Please provide the proceeding as well as the report. Or if you will be the opposite party, when you will appear before the executive magistrate, automatically you will get the copy of this PR report.
I have to.
Then of this court, that's why please understand, you are challenging one order, but the total document is not there. If you can, this court can appreciate, yes, the report on the basis of which the proceeding has been initiated, that has not.
John, that matter I will look into, and for that reason, your lordship was pleased to ask the state to call.
But I am telling you are the petitioner, because state is nowhere. State, what the state will go here and there. It is your case to, you have to prove.
But I have not got it. So and for that reason,
That's why, where is the averment you didn't get
that
it?
is not in the part of
Then-
my abandonment. My lord, my humble submission and direction may be given to the state to produce
The
the PR.
petitioner has filed the present application challenging the impugned order dated 7th of December 2023 in NGR case number 1586 of 2023, pending before the Court of Subdivision Magistrate at Jalpaiguri. Full stop. Counsel for the petitioner submit that the subdivisional magistrate has issued the impugned order dated 7th of December 2025 without any reason. Full stop. This court find that the petitioner has challenged the impugned order, wherein the subdivision magistrate on receipt of the PR number 2595 of 2023 dated 31st of October 2023 has prima facie satisfied that there is an apprehension of breach of peace over the issue, and accordingly, by invoking the provisions under section 107 of the CRPC, directed the petitioner to appear before the learned magistrate before the subdivision magistrate on 21st of December 2023 and to file so cause as to why they should not be directed to execute the bond of 5,000 each to keep peace in the locality. Full stop. Though the petitioner has challenged the said impugn order, but the petitioner has not disclosed the PR number on the Kotwali PS PR number 2595/2023, on the basis of which, after being satisfied by the subdivision magistrate, and issued has initiated the proceeding under section 107 of the CRPC. Full stop. Without the PR number, without going to the PR number, the petitioner has filed the present divisional application challenging the impugn order on the allegation that the London subdivision magistrate, without any reason, has started the proceeding. This court failed to appreciate the submission made by the counsel for the petitioner. If the petitioner had not gone through the Kotwali PS White PR number 2595/2023 dated 13th of October 2023, how the petitioner come to know that the subdivision magistrate without any reason has issued the impugn or has initiated the proceeding? In view of the above, the revisional application is dismissed. However, this order will not prevent the petitioner to challenge the proceeding, if any, not prevent the petitioner for taking appropriate steps in future if the magistrate has passed, if the subdivision magistrate pass any order against the petitioner. Grateful. See, filing the revision, you file, come with all documents. He done the state has not filed.
On last occasion, your lordship was pleased to call for a
Yes.
report.
Yes, I call for the report, but I have gone through that. You have not disclosed. It is your case next. 21.
Yes, my lord.
Yes.
The financier, Siram Finance.
Yes.
Your lordship remembers the fact that FIR was gone through, charge sheet was there, but our involvement was not there at all. But we have been named in the charge sheet.
Yes, it is there.
21, I remember. No, my lord.
It is not there.
There is nothing in the charge sheet. Really, but there is nothing more in the city. Charge sheet is very clear. And we are proceeding with respect to only two petitioners who happen to be the employees, branch manager of Siram Finance.
Yes, Mr. PP.
My lord.
What is the ingredients, what is the material against this petitioner? Have they issued any check? Have they withdrawn any amount, or have they taken any benefit? That's why I given the time on the last occasion. Because your police authority charge sheet is very cryptic. Consulted with the senior and filed the charge sheet.
My lord.
And these two petitions were added as 6-7.
I don't know how they consulted with the senior. Why you are not giving the gist in this FIR?
They should consult the trial court PP, my lord, before they submit.
Trial court PP, no. Charge sheet, you sit with the senior officer, inform the charge sheet is to given the total gist, so
Gist
that
of
the
it.
court cannot go all the document. The gist itself can prove that yes, this is the document, again this is the document.
We have seen in all the cases, my lord, particularly in this area, charge sheets are written in this way. my lord.
That's what I'm telling. For the last 5 years, I am saying
The
this
same
only.
thing, my lord. We are also just saying the same thing.
Yes, what is the allegation? What is the material? Because they are saying.
কালকে তো বলা হলো, পরশুদিনও বলা হলো।
In
বলেছেন?
fact, there is no material at all.
But
Our police, we have done our part, my lord. We have informed the police station. We have sent the message in all occasions to Pradhannagar police station. Previously, the IC was present on the last occasion of Pradhannagar police station, my lord, on 15. From our side, my lord, we have done. আর কোনো সিডি নেই?
You have not gone through the record of this case. You could have been gone through. You could have been checked what are the allegations, what are the material, because they have enclosed the charge sheet here.
But এটা কপিটা
What is our fault? We have paid, we financed the vehicles and on default we repossessed it.
আছে
The section is 379. How can we be held liable for the commission of theft?
দিব্যেন্দু দত্ত। Malad, one thing can be done, let them, copy may be supplied to us at two, Malad,
All matter not. Though the petitioner has argued the matter at length, but the prosecution failed to produce the CD, and without the CD, it is not possible for this court to decide the matter. According cases,
Interim order
let-
be extended.
Let the matter appear before the next available. Interim order, where is the interim order?
My lord, interim order be extended
Where is the interim order? Earlier there was
Yes.
interim order.
by Justice Sengupta in last occasion, last circuit.
The interim order is extended till the next date of hearing.
4 weeks.
Is extended till 30th June 2020. Or until further order, whichever is earlier. Next.
22.
Yes, what is CRR?
22, Lord, I have a question. Lord, this is that matter in which your lordship was only concerned with the Lord, offense of trespass. The other sections, my lord, I had satisfactorily satisfied your lordship that there is no case made out as regards forgery, cheating and all of that. Lord, may recall, Lord, will kindly take up the charge sheet once. Page 16.
CD is there.
no, my lord.
Lord, then the interim order may be extended. So there is a TRAN filed in the month of November.
The prosecution failed to produce the case diary.
Can I copy?
According case adjourned, let the matter appear before the next circuit.
Lord, there is a CRAN filed, my lord, before the expiry of the interim order.
The petition has filed an application being CRAN number
My lord,
One.
CRAN is 1.
1 of 2025, praying for extension of interim order. Interim order is extended till 30th June 2026 or until further order whichever is earlier. CRAN is just
I'm grateful.
next.
23.
Yes.
Interim order that is subsisting, my lord, and
Yes.
the interim order is extending, is up to May, in end of May. ma'am.
Yeah. CD is not there.
No.
Where is the application?
My lord, it's subsisting till the end of
Huh?
May.
Application file, case of 300.
The petitioner. Counsel for the petition submitted the interim order is till 30th, till the end of May 2023. And as such, he prays for extension of interim order. In view of the above, the interim order is extended till 18th of June 2026 or until further order whichever is earlier. Let the matter placed before the next hearing. Next.
24.
24 is for extension of interim order. The interim order is till the end of this month, my lord.
Same order. Same order. Next.
Next one is the
25.
Same, my lord.
Same order. Next.
26.
My lord, 24 এ কি আছে? 24
I mean,
Yes.
But this has been served, my lord, but the opposite party has not appeared, my lord, private opposite party.
Item number
26.
26. Yes.
And this was a
Supplementary
498A, my lord, I am the complainant, my lord.
Yes.
I was the complainant before the police, my lord,
Ah.
subsequently acquitted, my lord.
Ah.
That we have challenged by way of provisional application.
You are the complainant.
Complainant.
Is there appeal against acquittal?
Yes, my lord.
Is there appeal against acquittal?
Yes, my lord.
Who is
My lord,
appealing?
the main facts, my lord, the trial was not conducted by the legal aid, properly, my lord.
Ah.
All the facts that are very pertinent, nothing was placed before the
Trial
learned
is
ma-
conducted by legal aid
legal aid, my lord.
of the prosecution.
My lord, the defense,
This is a complaint case or GR case?
GR case, my lord. But
So how the legal aid will go?
my lord, the legal aid was given charge, my lord. There is a serious allegation that the councils have.
No, legal, how the government case has been conducted with the legal
No,
aid?
my lord, defense.
Ah.
The defense had taken the aid of legal aid.
Ah.
Now, when the defense was to be placed,
Ah.
and even the prosecution tried to assist the prosecution, my lord, but the case was not made out, man. But there are documents on record, my lord, that shows that there are ingredients.
You are the complainant.
I was the complainant, but that was never placed before the learned magistrate or the
Where is the
additional.
service?
No, it's on record, my lord. It's filed a long time before, my lord. Whereas first appeal is also pending before the division bench, my lord, with respect to the divorce proceedings. And in that regard, my lord, another counsel is appearing. But here, my lord, none is appearing on behalf of the husband.
Divorce proceeding, what is the what was the section?
My lord,
What was the section?
divorce.
Here,
My lord, 498,
498 34.
34.
So you are the wife.
Wife.
You are the wife. And you are the accused?
Yes, my lord. I was rescued by some person.
Who is the accused? Husband and?
Husband and father-in-law.
Father-in-law. Caused by the district judge?
District and sessions judge is in appeal, my lord, Kalimpong. From
In appeal. Where is the magistrate order?
My lord, certified copy. Document.
So you preferred an appeal against the acquittal before the session judge?
Sessions judge.
And session judge has acquitted.
My lord,
the order.
confirm that because my lord, here also, my lord, the same councils have, my lord, there are documents in the revisional application which show that I have been subjected to cruelty and for which I even committed suicide, but it was rescued by the doctors. All these medical documents were never placed before the trial court, my lord.
So during investigation, it was
Nothing, my lord. The investigating agency was in hand in glove with the accused person.
It was not seized.
My lord, it was the investigating agency was in hand in glove with the accused person.
I am asking one question.
Not seized, my lord.
It was not seized. So what is the lacuna of the trial court?
My lord, it was the duty even of the councils, the learned advocates, to place before the learned trial court that these are the documents, my lord. But the council himself, my lord, there was a big foul play against the petitioner, my lord. That is something from record we can be derived, my lord. That is why the opposite party is required.
You are appearing, my lord. So
But there is no entry.
why your state has not conducted the trial properly? As for the allegation, I don't know what is there.
My lord, I have no information.
Huh?
I have nothing to say, my lord, because I don't have the CD, my lord.
None appears on behalf of the opposite party. The petition is directed to inform the next date of hearing to the opposite party and to file the affidavit service. This is the matter before the next available circuit bench.
My lord, if a date could be given, my lord, I could intimate that date, my lord.
I don't know what the court will take or not. If I know, this court cannot fix that. Next.
27.
Lordship, in this case, I am the claimant and the insurance is the appellant.
Who is for the appellant?
Lordship, I'm praying for short pass over, Lordship.
When short pass over?
Senior is on.
Who is your senior?
Supriya Singh, Lordship.
What is the ground for appeal? Insurance company has prepared an appeal or the
Yes.
claimant?
Insurance company.
Insurance company. What are the ground?
Lordship,
don't
I have
know.
no instruction, Lordship.
Pass over. Next.
Lordship.
28 and 29.
There are two appeals, my lord. So one has been filed by the petitioner against the insurance company, and another appeal has been filed by the insurance company. So both the appeals are being heard together, my lord. So it's a very small and the issues are very small
You are
issues.
appealing for?
It's petitioner, my
Which
lord.
for the insurance?
Insurance company is coming actually. He's the junior is coming. He's coming. He's outside. He's coming, my lord.
What is your ground?
Only ground
The
is
claimant.
uh,
You are the claimant.
I'm the claimant, my lord.
Where is the order award?
Award, my lord. My paper book.
20.
Paper book. Yeah, we have
So
filed. My lord, paper book is there, my lord. Paper book. Paper book is there.
Yes.
Yes, page number 19, 20, and 21, my lord.
Yes. What is the ground of the appeal?
Ground is, my lord. Actually, the appeal has been filed, and actually case has been filed under section 163A. So my lord knows it better than me, my lord. Actually, after the amendment, my lord. So there is a fixed compensation. So there is a fixed compensation of rupees 5 lakhs. In case of 163, which has been amended to 164 subsequently, which has been done in the year 2018, and notification was done in the year 2019. So far the notification is concerned. So this is the notification.
The permanent disability.
No, it's a death case.
So death case, why?
In death case, there is a fixed compensation of rupees 5 lakhs. Sheet A number point, fatal accident. Schedule for compensation for third party fatal accidents. This was the schedule. And let me complete, then you come. So this is the latest scenario, and the order has been passed in the year 2023.
163 you filed.
Lordship.
Correct.
Lordship.
You are the government servant?
No.
So how you can file the 163? How you prove your income?
No, Lordship. There is no question of proving any income, Lordship.
You are harping upon the 5 lakh.
Only 5 lakhs and 5% increasement in each and every year, Lordship. So far the amendment is concerned, Lordship. And so challenging this order, actually, the insurance company prepared one appeal, and before the Honorable Calcutta High Court, Honorable Justice Dipankar Datta's bench. So actually the judgment was that actually the issue was that whether the retrospective effect should be given to the appeals which have been filed previously. So challenging that order, the Honorable Justice Dipankar Datta actually passed the judgment in favor of the petitioners that retrospective effect should be given and the petitioners should not be deprived. So challenging the order of the Honorable Justice Dipankar Datta, one appeal was filed before the Honorable Supreme Court. SLP was filed. So that appeal was pending for a long time, and subsequently verdict has been given. And so for the judgment of the Honorable Supreme Court, that even if the case has been filed prior to the amendment, so in all those cases, retrospective effect should be given. So this is the judgment of the Honorable Supreme Court, where the Honorable Supreme Court has categorically observed there is no need to interfere into the order passed by the Honorable Calcutta High Court. The relevant parata bol rahe? Paragraph number 10, my lord. Paragraph number 8 is also very much pertinent. So in this case, 4,80,000, 4,82,000 has been passed, Lordship. So with interest at the rate of 9%, my lord. So challenging that order, so we are paying for rupees 5 lakhs, only 20,000 in.
How the Leonard trial court and the tribunal has come to say 3,300. That is.
Lordship, Lordship, let me complete, please.
How the 3,300 trial court, the tribunal has come to that conclusion?
Trial court in case number 19, Lordship, of the judgment paper book. It appears from the election photo ID card, that is exhibit 1, that the victim was 66 years old on the date of accident. Since the veracity of the exhibit number 1 has not been challenged by the OP number 2, there is no legal impediment to hold that on 66 years old on the day of a date. It is claimed that from the side of the petitioner that the victim was daily rated earning 3,300 per month. So considering the given economic scenario, earning of rupees 3,300 per month cannot be regarded exclusive. So here the earlier actually this case was filed. This case was in the year 2017, my lord. So prior to the amendment. So prior to the amendment, so the petitioner has filed this case. So at that time there was no scope for filing the claim under section 1 for compensation. So accordingly, they have, since the deceased was the mother and she was a lady and she was delegated labor, so we have paid accordingly. Now the question is after the amendment and even after the amendment order has been passed. So in our humble submission, my lord, so at least when the amendment was passed prior to the judgment, so that the just compensation and keeping in mind that it is a beneficial legislature, so appropriate compensation should be passed in favor of the petitioner. On this point, our Honorable Calcutta High Court passed the judgment comprising the bench of Honorable Justice and Shampa Sarkar in the case of HON'BLE Haldar, and even the Honorable Calcutta High Court passed the order that actually. Yes. So hello. Sorry, excuse my lord. But so keeping in mind the observation passed by the Honorable Calcutta High Court Division Bench that retrospective effect should be given. So since this case has been filed prior to the amendment was done in the year 2018 and came into effect in the year 2019. So this case was filed prior to this.
Okay, yes. Where is the insurance company? Yes. What is the contention?
Our appeal is that.
Where is the paper book? What is your contention? What is the ground?
Our appeal is that admittedly the case has been filed under 166.
Huh?
163A. The case has been of the accident of 2017, and their claim was in paper book page 4.
Page 4.
Page 4.
Yes.
It was they have calculated and they have claimed 2,20,700.
2,20,700. Yes.
And in support of their contention, they have adduced two evidence, that is at page 10.
Yes.
In the evidence also they have page relevant para page 11.
Yes.
Para 5.
Yes.
And they have also deposed, rather, they have claimed also as in terms of their payers, 2,20,700. That is their claim, and accordingly, they have only adduced one evidence. Accordingly, the judgment was passed. But our appeal is that the lordship have filed the schedule because there are two sections 163. There is it is beneficial.
Prior to the amendment. Prior to the amendment.
There is no requirement of proving the ration negligence.
Correct.
And in 160, the prime consideration so that they have to prove the ration negligence beside the evidence. In this case, they have proved the involvement of the involvement of the vehicle, and the calculation is to be done as per their application as per the schedule. In schedule, our main grounds of the appeal is that the compensation has been rightly calculated, that is at page
Page 20,
19.
page 20 about,
19.
in our paper, page
Yes.
20.
Page 19, that monthly income has been rightly taken as per the schedule. Notional income 1/3 was deducted. Compensation was rightly calculated as 1,32,000, that is admitted.
Correct.
But the following portion, clause 4, 5, 6, 7 are our main contention of the appeal. It was allowed funeral expense to the loss of care and guidance, 1 lakh, that is never provided by the, because we get the benefit of section 163, we have to follow this schedule strictly. There is no provision of granting 1 lakh. Second round is
What
to-
about the Supreme Court judgment? What about the Supreme Court judgment
regarding
Pranashati?
Pranashati is
Not applicable.
Not applicable.
Okay.
They are also not condition. Funeral expense was allowed 50,000. But as per the schedule, funeral expense is, it has been paid at rupees 2,000. As per the schedule, loss of estate has been fixed at rupees, as that is also 2,000. Loss of loss of estate is 5,000, and but it was allowed in excess of to the tune of rupees 1 lakh, and there is also no hate of laws and affection which was allowed to the tune of rupees 1 lakh. So these portions are the main condition of our challenge.
Okay.
These are beyond the provisions of law,
Yes.
and this is also not claimed by the petitioner. If we go through the claim petition also, these have never been never or praised or pleaded or proved or claimed by the petitioner. They have claimed as per the schedule.
No, his case is that as per the notification, the minimum compensation is to be granted 5 lakh. What is your submission?
That
on
is
that?
fixed, that is subsequent.
Correct.
But our submission
But the
is that
Supreme Court has stated that it is retrospectively, not
retrospectively
prospectively.
that
I'm handing over the copy of the judgment.
See that.
See, page, paragraph
effect
number,
cannot be retrospective because
just
Can't
go
see
through.
that.
Just
That-
go through.
what is your
Paragraph number
answer?
8. Paragraph number 8.
because this case was filed earlier.
Yes,
That's why.
that's why Supreme Court to say.
That is regarding the subsequent amendment. So for this judgment is concerned, the
Correct.
schedule has been replaced by a fixed quantum.
Correct. That's I'm telling. The amendment was came into effect in 2018.
No,
It was
amendment-
19.
19 it was
Correct.
given in 2020.
Correct, 2018. I need see the notification.
Notification is not.
Notification. 22nd May 2018.
And now 160 total section has been omitted.
Abolished, totally abolished. Second schedule has been totally
There is
abolished.
no 160 at present.
Huh?
At present, there is no 160 in the NBA.
Yes, that has been
has been
abolished.
Totally omitted. and
Correct.
This is the
substituted by
notification. Kindly see the
Correct.
notification.
164 has come into
Coming,
effect.
coming to.
Correct. When the accident occurred,
2017.
2017.
then what is your submission on the notification?
Date of effect is not given, that is.
That's the Supreme Court, because the matter went to the High Court.
Yeah, whether the effect will be.
So that's why the
Because
matter went to
this
the
is
High Court. High Court
substitute law.
stated that it is retrospectively. If it is a retrospective effect, then the
Subsequent. That
So
is
what-
the break on.
so what can be done? the claimant as well as the insurance company both have preferred an appeal against the award passed by the Learned Motor Accident Claims Tribunal. Claims Tribunal within bracket Additional District and Sessions Court, comma Second Court, Siliguri, in MACC number 53 within bracket 7 of 2017, dated 31st of January 2023. In the appeal preferred by the claimant, the only ground taken by the claimants that the Learned Tribunal has considered the monthly income of rupees 3,30,300 per month and calculating all the heads has awarded an amount of rupees 4,82,000. He relied upon the notification dated 22nd of May 2018, wherein section 163A within bracket 3 of the Motor Vehicle Act was amended, and as per the said amendment, the schedule of compensation for third-party fatal accident or big injury has been notified. He submit that as per the said notification, the compensation payable in case of death shall be 5 lakh rupees, but the Learned Motor Accident Claims Tribunal failed to consider the said notification by awarding the rupees 5 lakhs, but had awarded only rupees 4,82,000 by taking into consideration of the monthly income of the petitioner 3,300. Land counsel for the petitioner submit that though the incident was occurred on
1/7/2017.
on first
No. Accident. 13th March 2017.
Where is the date of accident?
Page 5.
On 13th of March 2017. But the notification by amending the section 163 within bracket 3 of the MV Act was came into force on 22nd of May 2018. But the Honorable Division Bench of the Honorable Calcutta High Court has held that the notification will be affected retrospective effect and not prospective effect. And the matter went up to the Honorable Supreme Court, and the Honorable Supreme Court in the case of New India Assurance Company Limited versus Urmila Haldo in SLP within bracket civil number 6260 of 2019 has held that, has affirmed the order passed by the Honorable Division Bench of the Calcutta High Court by holding that the notification dated 22nd May 2018 will be retrospective effect. And as such, he pressed for enhancement of the compensation awarded by the Learned Motor Accident Tribunal from 4,82,000 to 5 lakhs. This is your submission only.
That's going to want correction over. Actually, this notification was done in the year 2018, but came in place September 1, 2009.
January. Came into force from 1st of September, January 19. September 19. On and from 1st of January 19. On and from 1st of January. See? Where is the notification?
The notification that is not mentioned.
1st September 2009.
1st September? Where from you get? On and from 1st January 2019, the amount of compensation specified paragraph shall be increased by 5. No, that is not there.
Not mentioned.
Where from you got?
Actually, I know Google, but this is, I guess it mentioned about the notification itself.
Where?
At the bottom, number 2.
Bottom 2. That is in January with regard to the ABC 5%.
5%.
No, that is,
Immediate last September 2019.
where is that?
Online, I can.
Show me. You have not brought the formula of judgment of the High Court.
I got it.
So that will be clear. Okay, full stop. Number next. Learned counsel, full stop. The insurance company has preferred the appeal on the ground, preferred the appeal against the award, against the impinging award, on the ground that the claimants in the claim petition have admitted their monthly income is rupees 3,300 and the total claim of the claimant was rupees 2,20,700. But the learned tribunal has awarded the compensation of rupees 4,82,000. 4,82,000. Learned counsel for the insurance company has further drawn the attention of this court that while awarding the compensation to the claimants, the learned tribunal has considered the loss of care and guidance of rupees 1 lakh, funeral expenses 50,000, loss of estate 1 lakh, love and affection rupees 1 lakh, but as per the motor vehicle, as per the schedule of 163A of the Motor Vehicle Act, the funeral expenses should be only rupees 2,000, loss of consortium is only 5,000 and loss of estate is only rupees 2,000 and 2,500. He submitted the learned tribunal without considering the schedule of 163 of section 163 of the Motor Vehicle Act has passed the award by awarding the amount of rupees 4,82,000. It is there. It is there.
I see paragraph of 126, but it's not mentioned there.
Okay, I will see. Had the learned counsel for the respective parties peruse the materials on record. This court find that by a notification dated 22nd of May 2018, the compensation for the fatal accident has been fixed rupees 5 lakhs. 5 lakhs. Full stop. But the learned tribunal has only awarded rupees 4,82,000. That is with regard 4,82,000 by considering the monthly income of the deceased at rupees 3,00,300. The notification dated 22nd of May 2018 was under challenge and the Honorable Supreme Court has already passed under challenge. By an order in the case of Urmila Halda versus New India Insurance Company in FMA 446 of 2010, the Honorable Division Bench of the Calcutta High Court, where is the Calcutta High Court, has held that. Yes.
126, paragraph 126, 127, 128.
Held that Each and every case where the claim is pending before the tribunal or this court has been approached in an appeal as on 22nd of May 2018. The duty of the tribunal of the court to determine the amount of compensation payable to the claimant in terms of the structured formula and award interest at such rate it considered proper thereon upon the date of filing of the claim of the application till May 21st of May to May 2018. To avoid any charges arbitrariness, the SIP to award the no, where you stated that May 2018. Where you can get that retrospective? Very difficult. Interest.
That is the submission.
Yes, no, that is interest. Where is the point of law? Therefore, the conclusion to make a agreement under deciding pending claim. Come to 118. What says?
Therefore, the confusion seems to be inescapable. That why deciding pending claim applications have been post-May. Post-May 2020 from 18. Be applied by the time slash is code for determining compensation payable to the legal heirs of the accident, victim or the beneficiary, regardless of whether the link should be beneficial to them or not. But is accordingly answered.
लास्ट में क्या बोला अभी लास्ट पैराग्राफ क्या बोला हाँ the honorable division bench of this high court honorable division bench of this court that बाकी करो held that बाकी काटो held that while deciding pending claim applications appeal post May 22nd May 2018, the new schedule ought to be applied by the tribunal this court for determining compensation payable to the legal heirs of an accident victim or the victim himself, regardless of whether the new schedule is beneficial to them or not. The said order was challenged before the Honorable Supreme Court in the SLP Civil number 6260 of 2019 and the Honorable Apex Court by a judgment dated 8th of February 2024 has upheld the view taken by the Honorable Division Bench. Considering the judgment passed by the Honorable Division Bench of the Calcutta of this as well as the Honorable Supreme Court, as mentioned above, in the case of Urmila Haldar within bracket Supra, this court find that the tribunal failed to consider the notification dated 22nd May 2018. Though the learned tribunal has passed the impugn award on 31st of January 2023, that is after the notification. In view of the above, this court modify full stop. The contention made by the insurance company cannot be taken into consideration in terms of the notification dated 2nd May 2018. In view of the above, the award passed by the learned tribunal dated 31st of January 2023 is modified only to the extent that the petitioner is entitled to get the compensation of rupees 5 lakhs instead of rupees 4,82,000. Full stop. The interest has not been paid.
What has not been satisfied?
Huh?
What has not
No,
been
interest, what is the interest?
9% interest.
That is there.
5% shall stand increase, my lord, on each and every year. 5% shall stand increase.
Full stop. It is made clear that the non-counsel for the claimant submit that the insurance company,
Notification,
you are not deposit.
in notification, there is a, so far enhancement is concerned, that is not in the notification.
Which?
Interest portion, there will be enhancement which they are submitted.
Two. 1st September, January, no amount of compensation specified by AC shall stand increase 5% annually. क्या बोला?
No, 9% is not mentioned in the notification.
अरे increase.
Increase, yes.
Even land counsel for the
That is
payment
not-
submit.
so far
Have you deposited the amount here?
No.
So
There
how
was
the
no-
your appeal has been admitted?
There was no direction. We have given the statutory account.
Has not paid the but the claimant submit that the insurance company has not paid the awarded amount in terms of the award passed by the learned tribunal. Accordingly, the insurance company is directed to pay the compensation of ₹5 lakhs along with interest at the rate of 9% from the date of filing of the application till the realization of the said amount within a period of 60 days. Within a period of 60 days, full stop. It is further directed the insurance company while paying the amount, paying the compensation amount, also to take into consideration of clause 2 of the notification dated 2nd May 2018, wherein it is mentioned that on and from the 1st January 2019, the amount of compensation shall stand increased by 5% annually.
Kindly make it clear to where the insurance company will take it amount, my lord.
Trial court. No, trial court. Yes. Pay and within 16 days. Yes, they will pay that. The appeal is disputed. Both appeals are disputed.
mentioning one matter for extension of interim order.
That's why since beginning I am avoiding why you persons are filing one or the another application cran. Why you are not mentioning today you are mentioning, why you are not mentioning before all all the courts when before the expiry of the interim order? Why you are making all the CRAN application? Kindly see every day 10 or 20 application of the CRAN.
This order, notification has already been expired. Can be.
Yes. Pass over. हाँ? अरे पहले का पासओवर नहीं हुआ?
Passover matter, item number 3.
Your Lordship, I'm for the de facto complainant in this matter.
Yes.
I beg to differ to virtual.
No allegation of section clause.
Huh?
Is this particular petition as such?
What is the section?
The sections are 126 to 394,
Hmm.
117, 74, 78, 324. This case is the counter case which we have lost. Initially, our case was lost. Thereafter, just to escape from such litigation.
Where is your case?
At page number 15.
15.
15 is our FIR and page number 10 is the FIR of this present case. Principal accusation report. The charge sheet is also submitted, and in the charge sheet also there is no section of 12 is incorporated against this petition.
Where is the charge sheet? No, first this is your FIR.
My
This-
FIR is at page number 15.
12 to 14. 12 to 14, the first charge sheet. This charge sheet of which case?
Actually,
FIR number?
actually page number
FIR number 845. Lodged by?
Lodged by.
FIR number. They have
बंद कर दो ना।
FIR number.
Small indulgence, Your Lordship. I cannot hear Your Lordship.
কি অর্ডার আছে?
Not to enter. Yes, what is your submission?
But the order has been passed not to enter the jurisdiction of NGBPS.
Yes.
In this matter, your lordship, as the petitioner has submitted, it's a consequential action. But instead of that, your lordship, the incident has occurred prior to they have filed an FIR. They have filed an FIR on 15th. That was, if your lordship could come to FIR that we have lodged. It is there in page number 10, your lordship. It has been.
My question is what is your submission with regard to the grant of bail to this petitioner, where the main accused has already been granted bail? First thing. Second thing, against them, the section 12 is not applicable. There's no allegation against the section 12 of the POCSO against them, only the 74.
Your lordship,
What is your submission on that?
Your lordship admitted that the principal accused been granted bail, but these people were never in the custody. They were never produced. If even after the incident, in the charge sheet only, they said that they have tried all their means to, and they are residing just 2 or 3 houses away from my house, your lordship. If they are already on their bail, they will intimate me on every ground, your lordship. The girl is still still in medicines, your lordship, taking depressions medicines, your lordship. There's high probability they'll tamper with the evidences. The evidence stage is not even started, your lordship, as subject to correction and for the limited knowledge that I have with this with the trial procedure. The evidence has not been started yet.
The petitioner has filed the present application. Petitioners have filed the present
Milords, if I may add
application
one.
for grant of.
Milords, if I may add, Milords, what happened on the last day, because the
Who is appearing? You are appearing or she is appearing?
Milords, she is appearing.
Then have you taken leave from her or leave from the court?
No, Milords, I apologize, Milords.
Yes.
Milords, what has happened is the de facto complainant and her mother are in court today, Milords. Milords, when they are in court, they are present in court, Milords. The de facto complainant and her mother, Milords. Milords, when I asked
De facto complainant and her mother. De facto complainant is the mother.
means
And
the
her daughter.
and her daughter. Milords, the daughter is present. So when I took the details of the case, because they had not received the documents, they had just received the intimation that they are to appear before the honorable court, Milords. Milords, what had happened during the bail, Milords, when the principal accused was granted bail, Milords, similar notice was sent to them to appear before the CJM, Milords. Milords, when they appeared over there, she did not know what was going on. She could not, basically she could not oppose the bail application, Milords, and bail was granted to him. She did not know what was going on. This is what they have communicated to me.
That is different.
Yes, Milords.
Now here, these are the 4.
No, Milords, I am not.
These are the 4 persons as per the allegation in the FIR, and what is the reveals from the investigation
Yes,
of this, from the CD. It reveals that the only allegation against the persons that with the mother is 370, that is 354. Correct. 354 is the only non-bailable.
Yes, ma'am.
Section 12 is not applicable to this person. So regarding in this matter, the victim is the de facto complaint.
Yes.
Correct. So now the main accused is already on bail and only 354. So why the custodial interrogation is required? That is the only question. Filed an application for grant of anticipatory bail for anticipatory case in connection with Jalpaiguri PS case number 845 of 2025, dated 15th of December 2025.
Very good future.
Under section 126 within bracket 2/329 within bracket 40 and 329 within bracket 4/117 within bracket 2 117 within bracket 2/74/78/324 within bracket 4/351 within bracket 3/3/5 within bracket 5 of the Bharatiya Nyaya Sanhita. The counsel for the petition submit that the petitioner number 1 and the petitioner number 4 are the father and son. The petitioner number 2 is the brother of the petitioner number 1, 2, and petition number 3 is the son of the petition number 2. She submitted the petitioners are no way connected in the present case and have been falsely implicated. She has drawn the attention of this court to the FIR paragraph 9, wherein only the allegation that these petitioners have entered into the house of the complainant and have threatened and abused and threatened the complainant and misbehave with the complainant. She submit that against this petitioner there is no offense and there is no case under section 12 of the POCSO Act is applicable. She further submit that the main accused against whom the POCSO Act is section 12 of the POCSO is applicable has already been granted by the Learned Court of Special Judge. She submit that if this court grant anticipatory bail, the petitioners will appear before the investigating agency officer and will cooperate with the investigation. Learned Counsel appearing for the de facto complainant submits that the principal accused was granted bail by the Learned Special Judge without being given any opportunity to the victim. They further submit that the petitioners are residing just 2 or 3 houses nearby the house of the complainant and the victim, and if the petitioners have been released on bail, there is every chance that again they will threaten and abuse the complainant and the victim. Full stop. Learned APP in charge along with the IO is present, CD is produced, police are considered. In the Learned Counsel, when the Learned APP in charge submit that the investigation is still going on and the petitioners are residing just adjacent to the house of the complainant, and if the petitioners have been released on bail, they will hamper and tamper with the evidence, and there is every chance that they will threaten the witnesses. Full stop. Learned Counsel, full stop. Heard the Learned Counsel for the respective parties peruse the materials on record. This admittedly, section 12 of the POCSO Act is not applicable to FIR. The petitioners have illegally entered into the house of the complainant and have dragged the complainant and touched the complainant inappropriately to attempted to strangulate the complainant. Full stop. This court finds that the Learned Special Court has already granted the principal accused granted bail to the principal accused. There is no complaint has been lodged either by the complainant or the victim with regard to misuse the liberty of the bail by the principal accused. Full stop. Considering the above, this court find that the custodial interrogation of the present petitioners are not required. Accordingly, the anticipatory bail application and according the application filed by the petitioners allowed. In the event of error, the petitioners shall released on bail on furnishing bond of rupees 5,000 with 1 surety each. Full stop. The petitioners shall not entered into the jurisdiction of the NJP police station till the report in final form is submitted. Charge is submitted. I didn't find it. Then what remains?
Stringent conditions
With the condition that the petitioners shall not hamper or tamper with the evidence. Number 2, the petitioners shall not shall appear before the trial court on each and every date of hearing. Full stop. Same present to this. CD is written, huh?
Item number 4.
Next.
Item number 4.
Lordship, allegation of rape level against the present, allegation of rape level against the present petitioner, Lordship.
376.
Yes, Lordship, presently 64 of.
64 of
BNS.
the PNS.
Yes, Lordship.
Yes.
Lordship, page 9 is the FIR, Lordship.
Page 9.
Yes, Lordship. Lordship,
FIR is in Bangla or English?
Bengali, Lordship.
Who are you? On sole accused?
Yes, Lordship.
Sole accused?
Yes,
What is the age of the
Lordship,
what is the age of the victim?
Lordship, age of the victim, Lordship,
He is a major.
major about 40 years, and the present petitioner is the 64 years.
Good.
Yes, Lordship, they are the family members, Lordship. What happened, Lordship?
Family members?
Yes, Lordship.
What is the relation between you and the complainant?
Sister, cousin sister.
Cousin sister?
Yes, there is a property dispute between the family members, Lordship. And on that instance, several complaints has been made against one member to another member, Lordship. Lordship, in the FIR itself, the complainant stated that his father is with the present petitioner, Lordship. Lordship, what happened? The
Yes, father
of the complainant is with the present petitioner, Lordship. What happened?
with the present petitioner means supporting the petitioner
Yes, Lordship.
and against the de facto complainant, against the victim.
Yes, Lordship. What happened, Lordship? Lordship, the complainant and his brother started torture upon the complainant's father.
What?
The complainant and his brother started.
Who is the complainant?
Lordship, one Amina Khatun.
Victim lady.
Yes, victim lady and his brother started torture upon their father, and on demand of some portion of land, Lordship.
Correct.
And the father taken shelter of this petitioner's house, Lordship, and supporting the father of the complainant, Lordship. And on that instance, to indulge this petitioner in a criminal lecture, this false complaint has been lost, Lordship. And Lordship, I have kindly peruse the page 11, Lordship. That is the one complaint before the SDO Dinata. Under the maintenance and welfare of parents and senior
Who
citizens.
filed?
The father of the present complainant.
Father of the victim.
Yes, Lordship.
Father of the victim has filed an application under section 5, under section 6.
6.
Yes, before the
Before
sub-divisional.
SDO Dinata
Against the
against
daughter.
the
Against the daughter.
elder son, against the elder son, and the present complainant is associated with the elder son, Lordship. And this false complaint has been lodged, Lordship. This is a completely family dispute, Lordship. And the father also filed a writ petition before this honorable court, Lordship.
For?
Initially, Lordship.
For what? Writ petition for what?
To establish a maintenance, register a case by the SDO Dinata, Lordship.
Correct. That is the Senior Citizens Act.
Yes, Lordship.
Yes, then
Lordship, this is the whole
so
fact,
your
Lordship.
case is that the petitioner has been falsely implicated.
Yes,
because
Lordship.
your petitioner is supporting the father of the victim.
Yes,
And the
Lordship.
father of the victim has filed a case under the Senior Citizen Act against the husband of the brother of the petitioner,
Yes,
the
Lordship.
victim.
Yes, and I believe medical report will not support because
Okay.
this is a completely
Anything
false case.
further?
Lordship.
That's all?
Yes.
Yes.
Lord, I have threefold contention.
Yes.
Lord, first of all, my lord, kindly consider, my lord, the relationship between the victim and my lord, the present petition.
Correct.
Is the, my lord, the elder sister, my lord, the petitioner happens to be, my lord, the brother.
Hmm.
My lord,
Cousin brother.
Cousin brother.
Family dispute.
My lord, the second contention is that, my lord, cluster of criminal antecedent is present against this present petition.
Why?
I have a reference, my lord. That is, my lord, Sahebganj PS.
That is correct. This is not the
126, my lord. Section 115, my lord, that corresponds to, my lord, 313, my lord, forceful miscarriage. Or the allegation is still, my lord, pending.
Of?
My lord, of BNS against this particular petitioner.
Against
this particular.
He is the complainant.
And my lord, that complaint, well,
313 case, who is the complainant or victim in that
my lord, the
case?
complainant is, my lord, is present, my lord, the victims, my lord, the sister-in-law, my lord, that is the elder brother's wife. Elder brother's wife. My lord, third one is that, my lord, immediately after, my lord, lodging this particular complaint against which, my lord, this petitioner is approached before this honorable court, my lord, the petitioner, along with his, my lord, associates, my lord, put the victim under pressure, my lord, she was criminally intimidated, my lord, to withdraw the entire complaint.
Several complaint has been made.
Assailing, my lord, that incident, my lord, one complaint has been lodged. If your lordship permit me, my lord, may I, my lord,
Who has
hand it
lodged the
over.
complaint?
Before, my lord, the concerned police station.
Who has lodged the complaint?
My lord, the victim.
After the
present
filing
victim.
of this case?
Yes, my lord.
Yes, what is the complaint?
Several lordship, this family.
This, what is the complaint? What she have mentioned?
My lord,
What is the complaint?
yes, my lord. She has narrated, my lord, that the present petitioner, along with his associates, my lord, put her into pressure. She was,
Threatening
my
for
lord,
withdrawal.
yes, my lord.
Okay.
Criminally
And-
intimidated her to,
Okay.
my lord, withdraw the complaint.
Habitual
And,
complaint.
my lord, other complaints that has been lost.
That's all.
So,
Habitual
custodial-
complaint here.
My lord, my humble submission, my lord, at this stage, my lord, anticipatory bail, my lord, may not be, my lord, allowed, my lord, because custodial interrogation is required.
Okay.
Yes,
where is
habitual
the-
complaint here.
Where is the PP in charge?
Lord, I think she, Mrs. Chakraborty is in procurement for.
Okay, CD is here. Yes. What is the
My lord, as per the, his name is Shahidul Khangal Kareres Laden, and as per the 164, my lord, rape on fear and threat of being killed. Only on the basis of that, she was raped, my lord. There are 161 statement, 164 is also page number 28. And allegations are very serious in nature.
Very general in nature, lordship.
Okay.
Lordship,
What has happened? But whether your IU has received the complaint dated 20th March.
Lordship, other than that, lordship may.
20th March, any complaint has been filed, whether IU has received that complaint?
No, in the city, my lord, it's,
Not. Where it has gone?
they have just,
IC Dinhata.
only GD has been done it.
Yes.
Lordship, this is a, lordship, kindly peruse this bill application. This complaint has been lodged by the brother, present complainant's brother's wife, lordship, against the present complainant's father and the present petitioner, lordship.
Okay.
Several lordship, several complaint has been.
My lord, this is not in the city because the case number has not been, maybe she did not know the case number and all. So that's why it's not written. So that's why it has been tagged.
The petitioner has filed the present application under section 482 of the BNSS 2023, praying for grant of anticipatory bail in connection with Dinhata Women Police Station case number 25 of 2026 dated 12th of March 2026 under section 127 of the 64 of the 351 of the BNS 2023 pending before the Learned Court of Additional Chief Judicial Magistrate Dinhata. Learned Counsel for the petitioner submit that the victim and the petitioner are the cousin, brother and sister. He submit that there is a dispute between the father and the victim, and accordingly the petitioner is giving shelter to the father of the victim. The father of the victim, the petitioner being the daughter, along with his brother, are not taking care of their father, who is the senior citizen, and as such the father had to file an application before the sub-divisional officer under the Maintenance Act, and the same is pending. He submit that as the petitioner is supporting the father of the father of the victim and only with the personal enmity, comma, the victim has initiated a false case against the petitioner. Against the petitioner. That's all. Any further?
Yes, Lordship, and
Learned counsel for
he
the
is the senior citizen
Full.
and I can bring the father of the complainant if required, Lordship.
He further submit that the father of the victim is the best witness, can say that the
Yes.
case initiated by the victim is totally false. False on false. Full stop. Learned counsel appearing for the victim submits that the relationship between the petitioner and the victim is the cousin, brother and sister, without taking into the consideration of the relationship, comma, the petitioner has committed the said offense with the victim.
May I be permitted to hand over? I have referred, my lord, one allegation against this particular petitioner under section, my lord, 313, forceful disclosure.
The petitioner for the learned counsel for the victim further submit that against this petitioner, another criminal case is pending for the alleged offense under section 313 of the IPC. 313 of the IPC. That the said offense has also been committed by, alleged to have been committed by the petitioner within the family members. Within the family. Learned counsel for the petitioner submit that after initiation of this case by the victim, comma, the petitioner has time and again threatening the victim and the victim has already made a complaint to the concerned police station on 20th of March 2026. He further submit that at this stage the petitioner is released on bail. There is every apprehension that the petitioner will again give the threat to the victim, and there is witness to withdrawal of the present case. Learned APP in charge is present along with the CD. Learned APP in charge submits that the offense alleged against the petitioner is heinous in nature. He has committed alleged to have been committed the said offense with his relative. Full stop. The investigation is going on. Full stop. If at this stage, comma, the petitioner is released on bail, comma, the investigation, there is every chance that the petitioner will hamper and tamper with the investigation. He further submit that several things is to be taken into consideration during the investigation, and as such the custodial interrogation is required. At the learned counsel for the respective parties peruse the materials on the record and the CD. This court find that the offense alleged against the petitioner is heinous in nature. He has alleged to have been committed the alleged offense against the victim, who is the cousin sister of the petitioner. From it is also the allegation that the petitioner is threatening the victim for withdrawal of the case.
Medical report.
In view of the above, this court find that custodial interrogation of the petitioner is required. And if at this stage an anticipatory bail is granted, there is every chance that the petitioner will hamper and tamper with the evidence. In view of the above, this court is not inclined to grant anticipatory bail to the
Lordship,
petitioner.
medical report.
CRM
Lordship,
dismissed.
medical report need to be considered, Lordship.
Yes.
Lordship, I think
CDB
there's no
written.
forceful.
CDB. Next.
5 for the petitioner. My lord, in this case, my lord, there are 5 petitioners.
Yes.
Out of 5, my lord, serial number 5 has already been arrested.
5 arrested, yes.
My lord, so for the sections are concerned, that is 325, 447, 506, 354A and 34.
354, what you will do?
Now, my lord, if your lordship can you take some pen to pen the FIR, that is the page number 14. That is the basic allegation of assault against one Narayan Pal, the FIR number 1, serial number 1 in the FIR, and Raju Bepari, the serial number 8 in the FIR. Against the said, except those persons, the allegation of torture is omnibus in nature. Now, my lord, my humble submission.
Whether the Narayan and Raju arrested?
No, my lord, I am the relatives of Narayan and Raju. For that reason.
You are for all the executioners.
No.
He is for the 5.
I am for the 5.
Yeah, Narayan is also there.
No, my lord.
My lord,
Can you see 5?
No.
Acha, 5 arrested?
No, my lord, no.
Nayan has been arrested.
Nayan arrested, not
No.
Narayan.
Narayan.
Narayan and Nayan is
Nayan
two
has been
different
arrested.
things.
Narayan
Two
is
different persons.
Narayan is
and
serial number 1, my lord.
Ah.
Nayan is serial number
First
5.
of all, my lord,
4.
he has to not press for Nayan.
I have already stated. I have already
Nayan has
stated.
been arrested. Yes. And now he has come for 4 actions.
4 accused persons. Shambhu, Rakesh, Bhikhu.
What is the allegation against this 4?
The allegation is omnibus in nature.
Omnibus.
Only the allegation against Narayan and Raju. And so far my knowledge goes, my lord, the victim is now in normal condition. I think his statement has been recorded. If he states anything against us, we have no case.
Yes.
Narayan and Raju are the principal.
Have you CD?
I have the CD, injury is grievous.
What is the
No,
injury?
that is not my
Who
case.
has
My case
assaulted?
would be, can you see the FIR, sir?
Who has assaulted?
Narayan and Raju. Against these persons, there is no allegation.
My lord, their presence were there in
My lord, my
Witness.
my lord, can you see the statement of the victim? If he stated anything against me, I have no case. Narayan and Raju are the principal actors.
Who will determine?
No, FIR.
From the FIR, you say it's principal accused.
They are the principal
After
actors.
investigation, some others may be the principal accused.
That maybe
At
that
the
may
time
be
of
no.
framing charge, some others may be the.
No, that is different. But so far the FIR maker is
At the time
concerned,
of passing judgment, some other will be the principal.
that may be. So far the FIR maker is concerned, she saw the
As
incident.
per the FIR, they are not the principal accused.
They are not a principal actor.
Very small.
Where is the statement of this victim? Who is the victim?
My lord, yeah, the victim is concerned, his name is
Brother of the.
Susanto Maji.
Susanto
Susanto Maji.
Brother of the defective complaint.
Bata the debate. He is the victim.
Yes.
Yes, sustained injury.
Brother of the defective complaint was given, some proposals in his.
No, that's why after that the complainant's brother was shifted. Complainant brother's name, what is the name?
Susanto Maji.
Susanto.
Susanto Maji. Where is the
Injury report
statement?
is there.
Now, where is the
His
statement of the
his statement.
Susanto?
His statement.
Injury statement of Susanto.
We did a statement of the Susanto Maji. Victim statement also?
She was injured for a long time.
Maybe my hands are not responsible. That is my submission would be. I have the access on FIR. So for the FIR is concerned, Narayan and Raju are the principal accused.
Something of the statement.
Principal assailants are 2.
She has stated all the people.
All the
No,
names.
because
Ukta Vivadi.
No,
He
no,
has stated.
can you see
He has
that?
not, he has stated ki all those persons were named in the FIR, that is stated.
no,
I'll just,
because as per the FIR, these two persons, the main
One
two
and
accused persons, as
They
asked
gave
for
them-
the sexual favor. In the meantime, the brother of the victim restrained, and this person assaulted the brother of the victim who sustained. So, and he sustained injury. So whether the brother of sustained injury, so how many injuries and whether this person participated in this injury, because the injury is caused through the bamboo. Who has assaulted with the bamboo?
So for the FIR is concerned, Narayan and Raju.
my lord, when they gave, for these two persons, they gave proposal.
Correct.
That proposal, and when he protested, then Amita Koti Lohar rod di Amar Matha, then these two persons.
Who?
These two persons.
Which two persons?
These two persons, that is Raju Bepari and Narayan.
Narayan.
They are not the
Ah.
মাথার শরীরে বিভিন্ন জায়গায় আঘাত করে সেই সময় উক্ত বিবাদীরা চিৎকার করে thereafter they shouted and the rest of these accused persons were the petitioners. They came, they also এলোপাথারি আমার মাথায় মারতে এলোপাথারি means randomly there. This is the case.
How many persons sustained injury? Only one?
Only one, my lord.
Susanto.
Susanto Machi.
And what about the victim?
Victim the de facto complaint did not sustain any injuries. And for that reason, section 75 has been added, that is sexual harassment of indecent proposals. It is not a case of 109, my lord, that is 307. The only section is 75 that is non-bailable.
But the main accuser has not been arrested. So
The
what-
main accuser yet to be arrested.
Then how you can be granted bail?
My lord, we are completely innocent, my lord. Being the family
Correct.
members of him, we have been implicated.
Correct.
Imposing any stringent condition, my lord, I will not enter into the jurisdiction.
No. You,
There
once
is-
you've been granted, then where is the principal accused persons? Because the police of the West Bengal is very competent to arrest the persons. Very competent. For the last 6 months, 2 months, they are not able to arrest the person.
But we are not.
If I will continue in this jurisdiction, then all police persons will be in difficulty. What you are doing? Only going and asking and have a cup of tea and returning back. 5 persons are involved, you are not arrested on any of the person.
My lord, only one arrested. No.
That's why.
We are not avoiding arrest, my lord.
Why you are not doing surrender?
My lord, we are seeking anticipatory for your lordship, my lord, because we are completely innocent.
The petitioners have filed the present application under section 482 of the BNSS, praying for grant of anticipatory bail in connection with Malbazar PS case number 95 of 2026 dated 14th of March 2026 under section 117 within bracket 2/329 within bracket 3/351 within bracket 2/75/3 within bracket 5 of the BNS pending before the Land Court of Chief Judicial Magistrate Jalpaiguri. Learned counsel for the petition submit that after the filing of the present application, the petition number 5, namely Nayan Paul alias Dhananjay Paul, has already been arrested, and as such, this application against the petition number 5 has become infractuous. Counsel for the petition submit that as per the FIR, the principal accused are Narayan Paul and Raju Bepari. He submitted that there is no allegation with regard to this petitioner that due to the assault of this petitioner, the victim has sustained grievous injury. Full stop. He submitted in the FIR, it is only mentioned that the petitioners were present. Only presence of the petitioner at the place of occurrence presence of the accused person's petitioner at the place of occurrence will not automatically can say that the petitioners have committed an offense which is not bailable in nature. He further submitted that the petitioners are the residents of within the jurisdiction of Malbajar PS, and if this court grant bail, they will appear before the investigating agency and will cooperate with the investigation. The PP in charge along with the investigating officer is present and produce the CD. This court find that the principal accused persons, namely Narayan Paul and Raju Bepari, are not yet arrested. The injury report reveals that the victim has sustained head injury with left temporoparietal EDH with right frontal hemorrhagic contusions with fracture of temporal and parietal bone on the left side. This court finds that the victim has sustained the grievous injury. So considering the above, this court is of the view that still the principal accused are not yet been arrested, and if this stage this petitions will be granted bail, there is every chance that they will hamper and tamper with
There is no allegation against me.
Accordingly, this court did not find any merit in the present application for grant of anticipatory bail.
My lord, principal accused
CRM
absent, there is no role of me.
Is dismissed. Next.
Principal accused.
11.
Of the petitioner.
Yes.
The state was directed to file a report, my lord.
Yes, you have brought the report, Mr. Chakravarti? No.
Again today, this is the
same report.
we are praying for time, my lord. This is a thing, my lord. It's not so easy, my lord. We have to do all the whether these two certificates, which is fake, which is original, those has to be seized. So
What is this application for?
let it be, my lord, in that.
What is the CRR?
Let it be sent back, remanded to the TCM. my lord.
Correct. What is the CRR?
CRR is for setting aside of the impugned order passed by the learned CJM.
Where is the order?
My lord, order dated, my lord, 10th September 2020.
Where is that?
Certified copy, my lord.
It's in the-
10th
10th
September.
September 2020.
A report is received from IC Kotwali. Seen the report, it appears the report occurred due to the regulatory norms of the insurance policy and non-submission of requisite by the complainant. No malafide intention of fraudulent activity insurance has been found. The matter is the technical nature gone by the insurance policy rules and IARP. Reveal that the dispute. Where is the complaint?
Lord, a complaint after 2 pages, Miss Petition 59 of 2025.
59.
Yes, my lord.
Yes, you, against whom you have filed?
Milord, against the opposite party.
That you
Milord,
can't.
on the face it appears
Sir,
that
I am
petitioner-
frankly, I am telling your complaint will not be sustained if at all this court will pass an order to take cognizance
Milord,
also.
may I suggest one thing, Milord? Let the impugned order be set aside and remanded back to the learned CJM, Milord.
I am dismissing this application.
Milord,
I am dismissing this application with the liberty to take appropriate step, file a press complaint. This order will not.
Milord, let the CJM consider all these facts.
No.
And, Milord, let him pass a fresh order, Milord.
Sir,
on the face
please,
it
you
appears-
see, you have been okay. This is the third, he is the agent.
Yes,
Correct.
yes.
The opposite party, Pankaj Ghosh, is the agent.
Agent of the
Correct.
insurance
Agent
company.
of the insurance
Yes,
company. But the certificate which is being given to you of the Reliance Commerce, of the Reliance General Insurance Company.
Yes, Milord.
Correct.
Yes.
That general insurance company. So if at all, suppose your vehicle was met with an accident.
Yes.
So where you will claim?
Milord,
Where you will claim?
insurance company.
Insurance company. And if the insurance company makes that this is the false report, false certificate.
Milord, may I interrupt? I was cheated with a fake insurance policy. Opposite party number 2 has cheated me. He has
How
hatched
you
up-
prove unless and until the insurance company has not made a party? From
Milord-
you, from whom you will receive the report? That's why the police is not able to
Milord,
submit the
he has
report. How the police
taken-
can submit the report with regard to your report? Because the police has not registered the case. Where is the complaint to the police?
Milord, I have made the complaint.
That's
Milord, my
why-
case was not registered, Milord. I have made a representation before the
Against whom you have made a complaint?
Milord, before the superintendent of police also I have made
Against
a complaint.
whom?
Against the opposite party number 2.
That is the problem.
Milord, let the case be remanded, Milord. Let the CJM hear the fresh, considering all these aspects, Milord. Milord, I have suffered a loss of 5 lakhs. Moreover, my vehicle is at low, hypothecated from the Axis Bank. Per month, I am paying EMI of rupees 61,000. 2 months loss I have suffered. Plus 5 lakhs I have paid. Kindly appreciate, my lord. My difficulty, my lord. This is a commercial vehicle. This is not a private vehicle, my lord. It is a 10-wheeler dumper truck. My lord, I am paying rupees 61,000 to Axis Bank. My lord, as an interest. This vehicle was purchased on interest. My lord, moreover, I have my vehicle met with an accident. I have to pay rupees 5 lakh for repair works. My lord, kindly appreciates, my lord. These opposite party number 2, he has prepared, he has hatched up with the insurance company and given a fabricated insurance policy. He has sold a fabricated insurance policy to me. My lord, thereafter, he did not tell me that the insurance policy was converted into a third party. I found out that from the Tata showroom that my policy was converted. Behind my back, my policy was converted. So the conversion of the insurance policy was at all according to IRDA norms or not, whether the rules prevalent to whether the conversion of policy was at all provided by the rules or
How
not.
many years you are having practice, sir? How many years you are having practice? Tell me. How many years you are having practice?
Almost 10 years.
10 years, correct. Your vehicle met with an accident. Your vehicle got damaged in the accident. At the time of, due to this, the damage, repair cost 5 lakh rupees.
Yes.
Correct. And the vehicle was remain in the garage for 2 months.
2 months.
2 months. Correct. And for the 2 months, due to this accident, you could not earn money because it is a commercial vehicle.
Yes.
Correct. So 5 lakh with regard to your accidental
Accident
charges,
damages.
the damage charges, the loss sustained
Loss
due to the accident. Correct. And 2 months damages with regard to your
EMI.
vehicle was idle.
Yes.
Vehicle was idle, you could not earn the money. And You had to pay the EMI because you have purchased the vehicle through the bank. Correct. Now you was free that if anything will happen, insurance company will take care of your all the
Because
things.
the insurance.
Just that I am taking the class here. Correct. So now when you claim the insurance policy, you came to know that the insurance policy the first party that is a fake, and subsequently it was transferred to the third party that is also without your consent. Earlier 55,000 and 53,000, then it was come to the 42,000.
Balance amount not been paid.
Balance amount not returned. Correct.
Yes.
Okay. So first thing, if you going to the damages, the criminal code, if at all, suppose you prove the case against this opposite party, yes, he has done the criminal act due to which you could not, but the criminal code cannot give the compensation.
But cheating, Milord.
Just a minute, you cannot give the compensation. First. Second thing, to prove the case that he has given the fake certificate.
That is what I am on.
That is on. You have filed the case.
Yes.
So that is to be. Who will say this is a fake certificate?
Let the
Who will say? I am asking you. That's why you ask how many years practice you are. Who will say this certificate is a fake?
let the inquiry officer find out.
Who will say?
The insurance company, Milord.
Then, if the insurance company is not a party, so how you will get the report? If you made the insurance company as one of the accused, the insurance company directly will come and file his report that, sir, I have not issued, this is the forgery. Immediately you will get. So you are not making that. You have made a person as a party. How you will prove? That's why the London magistrate rightly passed an order which you have made a claim that is with regard to the compensation and the damages. In the criminal case, it cannot be.
No.
And if the policy condition is there, then you have to go to the civil court for damages. And for the last 3 days, this court is also giving the option, but you are not ascertaining that.
Milord, at least direct a investigation officer to file a fresh report.
Sir, what the investigation? The police has not registered the case. The court will call. How they will register? Because no document. That
Milord,
amounts to direction by this court to the police to investigate into the matter, which has been denied by the London magistrate.
Yes, Milord.
Then
Milord, if at all, Milord, if I am being cheated, Milord, or is the insurance agent has hatched up with the insurance company, Milord. Milord, they have produced. I was handed over a insurance policy.
Correct.
I had full trust and upon the agent that my insurance
Correct.
party was
Correct.
first party insurance.
Correct.
For that, Milord, since it is a commercial vehicle, it has met with an accident, Milord, and from the showroom I found out that the insurance party was automatically transferred or whatever. It was not a first party insurance. So that is why, Milord,
recorded now.
Milord, kindly protect.
The petitioner has initially made a complaint to the police authority for taking appropriate action against the opposite party for cheating the petitioner on the ground that initially the opposite party has number one has issued the insurance policy certificate first party.
Yes, Milord. For
Of the first party insurance certificate
from
first
the
party.
certified copy, my lord will get the policy.
Just
number.
a minute. क्या बोलना? Issued the first party insurance certificate with respect of the vehicle number, commercial vehicle number WB53C 4574, which is valid from 6th June 2025 to 5th June 2026. For the said policy, for the said first party policy, comma, the petitioner has paid the premium of rupees 53,468. Subsequently, the opposite party number one also, only one, na?
Opposite party number two. Insurance agent, Milord.
Opposite party number two has issued another policy certificate of the said vehicle being number WP 53C4574, being the third party insurance.
Being the third party insurance, Milord.
Being the third party insurance.
Policy ending 060.
And the premium is shown for the said certificate is 49,460. Then it concept for the petitioner submit that the petitioner has not requested the opposite party number two for the third party insurance, but without the consent of the petitioner, comma, the opposite party number two has converted the first party insurance to the third party insurance, and even has not returned the difference amount in between 53,468 to 49,460. It is the further case of the petitioner that in between, during the period of existence of the insurance period, comma, the vehicle of the petitioner met with an accident. And when the petitioner has claimed the insurance amount, comma, the petitioner came to know that the insurance policy provided by the opposite party number one is not genuine and fake. Full stop. Initially, the petitioner has made a complaint to the police authority, but the police authorities have not registered the case. And thereafter, the petitioner has made a complaint made an application under section 175 within bracket 3 of BNSS before the Learned Court of Chief Judicial Magistrate, Kuch Bihar, against the opposite party number two for initiation of FIR. Learned Magistrate by an impugned order dated 10th of September 2025 dispose of the said application, holding that the complaint made by the petitioner is purely a civil in nature, and declined to pass an order upon the police authority for registration of FIR. By an order dated 24th of March 2026, this court has directed the ICPS Kotwali, Kuch Bihar to submit the report whether the alleged automatic conversion of the policy to a new one with less liability was at all intimated to the petitioner or was done according to the prevalent rule. In spite of the order, passed by this court, the inspector in charge Kotwali PS has submitted the report, praying for time to complete the inquiry. In view of the above, this court finds that it is the specific allegation of the petitioner that the opposite party number one has initially issued the first party insurance of the vehicle in question. Subsequently, it was converted to the third party insurance without the consent of the petitioner, and when the petitioner has claimed the insurance amount due to the accident occurred with the said vehicle, the petitioner came to know that certificates issued by the opposite party number two is forged out. In view of the above, the IC Kotwali is directed, in view of the above, the petitioner is directed to to submit to submit the certificate provided by the opposite party number one being party number two being, what is the policy number? Being policy number 716322523334 5 times 0 21 in the name of the petitioner is a Praveen Sultana. In the name of the Praveen Sultana, with respect of the vehicle bearing registration number WB53C 4574, which is valid from 6th January 2025 to 5th of January 2026, and the policy number 716322523349 5 times 0 60 in the name of the petitioner with respect of the said vehicle, valid from 6th January 2025 to 5th of January 2026 to the IC Kotwali PS, and the IC Kotwali PS is directed to ascertain whether the said certificate is genuine or not, and whether the opposite party number one fraudulently change the conversion of the policy from first party to third party. Let the said report be filed by the IC Kotwali on or before 16th of June 2026. Full stop. The petitioner is directed to communicate this order along with the copy of the insurance policies as mentioned above to the IC Kotwali PS for taking appropriate action. Now it is clear. Your authority can do that. Let the matter appear on the on 16th June under the heading orders. Next, I'm grateful.
Item number 14 to 18.
Now today the 3:30. What will do?
Malab, I have got the CD, Malab.
What is your instruction?
Malab, this is the two CDs, Malab. One is Pradhan Nagar 529, which was called for, and this is Pradhan Nagar PS case number 764. Malab, only one. Malab, excuse is that this could not be certified now. See, this is the one, and this is the.
764. 764.
দুটোই দিয়ে দিয়েছি, সব সিডি দেওয়া, তিনটা কেসেরই সিডি দেওয়া। এখন আপনারা 529 investigation proceedings.
764.
This is Malab, but the charge sheet has been filed on the last page.
Yes, charge sheet file. Final report, supplementary. And 529.
529, Malab, the investigation, present set of biggest investigation going on.
Investigation is pending.
Yes.
24.
2024.
Then
18/8/2010.
Jalpaiguri Police Commissioner. Pradhan Nagar. January 25, thereafter nothing. Last is 18 January 2025. Abu Talib. Ayo, thereafter nothing. It's difficult.
There, it is written in the last page of this, I just give the memo of progress, matter will be clear why it is pending. The third complaint,
Because of the High Court.
yes, my lord.
That is written here. Yes.
All are,
Huh?
all are not prosecuted with travel issue. Misuse of law. Series of cases pending.
Yes,
One of
Mr.
Prior to,
Chakravarti.
above all things,
Necessary order me first.
above all things, mutual divorce is pending.
No, mutual divorce is dismissed.
Yes,
No.
mutual divorce is
Was pending since
Pending.
20,
Dismissed.
dismissed.
no.
Mutual
since-
divorce is dismissed.
Yes, because below due to torture, my lord, I was not present at the time of hearing. After dismissal,
Perhaps
only
you,
instruction-
perhaps you are not,
With the after 6 months, it was supposed to be
Yes.
disposed of.
no, no, no,
but
no,
they
no.
have not
Perhaps,
given consent.
It is my instruction.
no, perhaps you are not aware of, because the mutual divorce case number was pending since 22nd of December, November 2019. Subsequently, post filing of mutual divorce, this series of cases has been registered. Only the issue was that, not only that, I'm giving beyond the pleadings and FIR allegation, the crux of the issue between the spouses was that the name of the baby after delivery was manipulated by the wife, which the husband petitioner has raised an objection, which was the crux of the entire list. Now, thereafter, manipulated and a fake birth certificate was issued, managed to get by the de facto complainant wife. That particular issue was
That is
challenged.
not
No,
considered.
I'm not saying that. I'm just giving the backdrop. That was challenged in the Reed court. Reed court intervened. Then that certificate was set aside.
Why? There is no chance of mediation. There's no chance of mediation. What the husband do?
He's an advocate.
And what the wife do?
No,
Huh?
no. Working lady.
No, what?
Working
no,
lady.
Not now, not now.
Not what is the qualification?
BA,
BA?
graduate.
So why it has not been settled? What do you want?
I don't know.
Huh?
Peaceful deciding.
Peaceful, how it can be? After this 4 case, whether you can be able to prove your case if the mutual divorce is dismissed. If he file the case under the cruelty, will what defense he will take?
Exactly.
You know the Supreme Court judgments.
Then,
One complaint against the husband if it is not proved that it is a cruelty.
if it is acquitted,
None.
is that
4 case.
there is a
That's why you are advocate, you are no work, you are unemployed, you are no work. Whenever you feel, you go to the Thana, whenever you go to the wife. Both are free persons. You find as I am free today, the Saturday, and go to the house of the wife and started abusing and then returning back, and she will go to the Thana and 498. Oh,
Lordship, above all things, may
I think I will write to Commissioner to open a new police station for all both.
Exactly. Above all things, Lordship, I am doing this case pro bono because he is my colleague.
I am
Colleague
also
means,
not legal aid.
legal aid.
Legal aid.
Above all things, Lordship, I have a personal knowledge regarding with upon talking with that guy. He attempted to commit suicide on couple of occasions, but his family members has rescued her because of the pendency
I
of
am
series of
receiving 2
litigation.
children, my lord. He
This
has
is-
not looked after.
Why are you not paying
No,
them
no.
amount?
No, that is being
If
paid.
they pay, there is an order, but did not pay regularly.
No, that
Okay,
you
then.
were not perhaps correct. One is adopted, one is biological, adopted by her. This is not mine. So that's a different thing.
There are several disputes.
That's a different thing.
Record unknown.
That's a,
The TP in charge has produced a copy of the case diary in connection with Pradhan Nagar PS case number 764 of 2024, dated 26th of November 2024, and Pradhan Nagar PS case number 529 of 2024, dated 18th August 2024. Let the same be kept with the record. CAV.
They will receive all materials has been placed, Lordship, 161 copy and all.
You do one thing. Come tomorrow with total details. Give to my court officer. I will see.
By tomorrow, Lordship? Or
Yes. By tomorrow. Tomorrow is the last date.
Or the CDs are written of that order.
I am kept. Yes, I have kept. I have recorded.
Record.
Record.
All the
Produce. Let the same be kept with the.
CD.
Doita to.
One is a Xerox.
One is direct, one is copy.
Another is there.
Where is?
Lordship, one thing.
And copy of and case number 99 of 2020. Let the same be kept.
Lordship, one thing I will try and point out, Lordship, the last two matters, since the charge sheet has not been submitted, I don't have any privy to that findings.
That I will, that's why I call the CD.
Exactly.
You do one thing, you give the 4 cases details tomorrow to my court office.